to discuss this. Thank you very much for that notion. Apparently it's being recorded. So at first, our first session will actually look at the way in which European Union law seeks to address the cooperation between competition authorities, the ECN Plus directive, and the application to the digital environment. And then as the afternoon progresses, we will be looking at progressively more aspects of the digital market and also issues related to intellectual property. We will have, of course, a very nice dinner for all of you who are here in the flesh. And we hope then also that these sessions today, but also tomorrow, contribute to a deeper understanding of the interface between competition law and intellectual property in digital markets. I hope you enjoy. We have a very tight schedule, and this is then also to all the speakers. Keynotes, 20 minutes plus 5 minutes for questions, and other contributions around 12 minutes. Keynote is 20, otherwise 12, and then followed by a comment, about 7 minutes, and then once more to fill up to 25 minutes. There is room for Q&A. We will be enforcing this time limit very, very strictly. And so this is the first rule of the day. Time is of the essence. So let's start. With that said, I hand over to the chair of the first session.
Thank you, Professor Kamperman Sanders, for this very nice introduction. Good. Our first panel focuses on the antitrust enforcement by national competition authorities and the transposition of the ECN Plus directive. The preamble of the ECN Plus directive refers multiple times to the importance of effective antitrust enforcement in digital markets by national competition authorities. Adequate investigative powers and the generalized possibility to impose interim measures are key in this context. Our first two speakers will discuss two cases where the national competition authorities of the member states effectively took enforcement action in relation to undertakings active in digital markets. It remains to be seen, however, whether the elements addressed by the ECN Plus directive are indeed central to the questions raised by the concerned cases. Our third speaker will address the question whether the measures taken by Albania, a candidate EU member state, following the entry into force of the ECN Plus directive comply with the obligations Albania undertook in the pre-accession stage. Since we have a full program and as you have heard, a very strict time schedule, I suggest that we immediately move on to our first presenter, Dr. Pim Jansen. He is Associate Professor at the Law and Markets Department of Erasmus School of Law in Rotterdam. Pim will discuss RPM and e-commerce after the final decision of the Dutch ACM in Samsung. Pim, you have the floor.
Thank you, Caroline. Thank you, dear all. I will discuss basically resale price maintenance in the context of a recent decision in the Netherlands on Samsung, where a fine of almost 40 million euros was imposed for undue price influencing. And what happened in this case? According to the ACM, Samsung coordinated the retail prices of Samsung television sets together with various retailers. So Samsung on the wholesale level and the retailers on the retail level, by exercising undue influence on the online resale prices of television sets of 7 retailers. And ACM accuses Samsung of having tried to prevent a so-called downward price spiral by de facto announcing market prices between a number of years. And while reiterating that monitoring online retail prices by suppliers is in and of itself, of course, permitted, the ACM found that the market transparency resulting from price comparison websites, retailers, online stores, and Sparta software allowed Samsung to analyze carefully the price fluctuations of its own television models and intervene, if necessary, by contacting the retailers. It may, of course, come as a surprise that the ACM qualifies the alleged conduct as a hardcore vertical infringement by Samsung. Because as you might know, price influencing as such is, unlike fixing prices, not automatically prohibited in a vertical relationship. A certain degree of price influencing is inherent in the commercial relationship between a wholesaler and a retailer. Suppliers can, for example, give retailers non-binding price recommendations. However, according to the ACM, the practices of Samsung have sufficient negative effects to qualify as a restriction of object, by object. ACM refers to the exercise of influence by Samsung, the assumed expectations of Samsung as concerns price, the assumed expectations of retailers as concerns price, the climate of price transparency, which according to the ACM discourages retailers from lowering their online prices. This raises the following question, and you may go to the next one. Yeah. This raises the following question: how should competition law classify vertical information exchange on pricing when this is enabled or facilitated by web crawlers, price comparison websites, and Sparta software? Does the exchange of information warrant a more flexible approach under competition law, or, as adopted by the ACM in the Samsung decision, a stricter approach? And from an economic perspective, and that's why I'm very happy that Niels will be responding to my paper. From an economic perspective, the question could be framed as, is the exchange of information between a manufacturer and a reseller more likely to lead to higher prices in a situation where price comparison websites lead to price transparency compared to a situation without price comparison websites at all? And as I only have 12 minutes, I will immediately go to my substantive analysis, if that's all right with you. If you read the decision of the ACM, the Dutch Competition Authority in Samsung, which is in Dutch, but there's a very nice English translation of the main parts of the decision, it appears that the ACM's strict approach in a decision is based on three economic and factual assumptions. Firstly, the implicit assumption that the competitive dynamics between the retailers, because of the transparency in the market, through web crawlers, price comparison websites, and Sparta software, necessarily results in lower prices. And secondly, the implicit assumption that lower prices are by definition beneficial to consumers, without considering other relevant competition parameters such as innovation and advice. And thirdly, that an agreement or concerted practice between Samsung and the individual retailers can be established based on the explicit assumption that there is an alleged common interest between Samsung and the retailers in the protection of the margin of both of them. And I will assess these assumptions briefly, and you can go to the next slide. So the first assumption that are identified, the implicit assumption, is that the competitive dynamics between the retailers, because of the transparency in the market, necessarily results in lower prices. Because in its decision, the ACM assumes that the transparency in the market, because of these technological means, leads to a downward price spiral of price reductions, which Samsung tries to prevent by actively intervening in the market by contacting retailers. The question is, however, whether this is necessarily the case. Tacit coordination, for example, is thought to be more likely when prices are transparent. So the ambiguity on the direction of the effect of transparency suggests that the ACM should not, without analysis, have assumed that competitive dynamics between the retailers necessarily result in lower prices. The second assumption, the focus on price only, even if we assume that the transparency resulting from price comparison websites and so on lead to lower prices. So even if we assume that the first assumption is correct, the question is whether it's really justified that the ACM solely focuses on the impact of price influencing on price levels. Because, as we know, there are more competition parameters, and the ACM does not seem to have considered the effect of price influencing on other competitive parameters, such as better quality, more choice, more variety, more innovation, more services, and so on. And it should have done so. And finally, and this is a bit complex, the ACM finds that Samsung entered into an agreement or a concerted practice with the retailers in accordance with which the retailers would not advertise or sell their televisions below the recommended retail price set by Samsung. And ACM refers from a case, Activision Blizzard Germany versus Commission, that it's not necessary to establish that Samsung exerted pressure or offered incentives to its retailers for there to be a tacit agreement to fix prices. And the fact that the ACM uses this reasoning already means that they're looking into indirect RPM instead of direct RPM. And the ACM takes into account two circumstances in assessing whether there was an agreement or a concerted practice. Firstly, it claims that Samsung and the retailers had a common interest in protecting their margins. And secondly, the ACM indicates that Samsung maintained a relationship of trust with the retailers through its account managers. And I find ACM's legal assessment surprising. First of all, the Activision case that I referred to is not a case in point because it did not concern RPM, but territorial restrictions, which is fundamentally different in this case. If you look at the case law of the Court of Justice, the decisional practice of the Commission, the decisional practice of competition authorities elsewhere in Europe, establishing RPM without an explicit agreement, pressure or incentives are a condition. But even if ACM's legal tests were sound, ACM's assertion that Samsung and the retailers had a mutual interest in keeping the retail margins or prices high does not appear to be based on sound economic theory, or Niels, at least that's what I hope. Because it could equally be argued that Samsung has an interest in low retail prices. This is because Samsung's profits decrease as the retailers' margins increase. If the wholesale prices is not amended, a higher price for the retailers means a higher retail price and lower volumes. I see I have to round up. I will come to my conclusion then immediately. Just one comment on the assumed relationship of trust. Even if there would be a relationship of trust, even in relationship of trust, this does not imply an agreement or a concerted practice, because firms can be in a trusted vertical relationship and yet have directly opposing interests as they both try to maximize their own profits. To conclude, so in this presentation, I briefly discussed the question whether in the circumstance of the decision where vertical information exchange is enabled or facilitated by various technical means, web crawlers, price comparison websites, and spider software, whether the more strict approach of the ACM is warranted. And of course, the answer to this question is highly relevant from the point of view of economic efficiency. Because for a vertical agreement to be efficient, a degree of coordination between the parties is required. And coordination requires information exchange. So it should not be condemned without a clear theory of harm. And I've tried to demonstrate that the ACM may have overstepped the mark. This is overstepping the mark by assuming harm in respect of price influencing that does not amount to RPM because there is no overarching agreement and no pressure or incentives. And given the fact that these assumptions have not proven to be correct, there is much reason to be less strict to require evidence of harm. Thank you.
Thank you very much. When lawyers make economic arguments, Niels cannot wait to give his reaction.
It's not among these. Okay, yes, it's on. Fortunately, you explained the meaning of that last picture. I was waiting for it. Wasn't sure whether this shoe was the appropriate picture. Okay, well, interesting topic for sure. And the ACM is always doing interesting stuff. Many of us know the ACM also for their fight on sustainability, to try to get that into competition law. Here we see something else. Well, what will I do in my limited time here, very limited, so 7 minutes? I will give some comments on the case, some additional comments on the case, also on the analysis of the case. A few comments where I slightly, well, disagree, if that's even the proper word. And I will also spend some time on the economics of RPM and how it may be relevant for this case. So I will extend a bit on the analysis, let's say. So first, well, you introduced the case, but I looked also at it, and some of the facts to me were, or the interpretations by the ACM were slightly different from how you seem to present them. First, it's obvious that the ACM concluded that the type of price influencing in the Samsung case, so Samsung towards the dealers, sometimes the dealers notifying other dealers to Samsung, hey, they're lowering the price, we have to do something about it. But especially from the Samsung side, was not individual and not without obligation. That's also what I found in the case. So in Dutch, niet individueel, niet vrijblijvend. So it means there is more, it's more than just signaling to some retailers that they need to adapt price. They were actually trying to do it to all of the dealers. And also, well, not without obligation. I mean, there was indeed perhaps no pressure. We can discuss about that. We can come to that, how far the pressure is going, but there were surely incentives here, as I will try to reason a bit later. ACM also collected evidence of this, lots of evidence. In fact, there was evidence collected through company visits, right, to the retailers, to Samsung, where they found WhatsApp messages, email messages, really lots of communication suggesting what was going on and that prices of competitors were going down. So we had to intervene, and Samsung was then contacting them, and so on and so forth. So a lot of evidence of repeated contact, so not just individual, like almost sector-wide, to the extent I could understand it. Yeah, the question then from a legal perspective, and I agree there can be different interpretations, is this really pressure or incentives? But I think the incentives are pretty obvious here, because we are talking about double margins indeed for both the retailers and for Samsung. The market works like this. It's really about these TV models, and normally they are introduced at a pretty high price, and very soon afterwards, because new models are appearing, they normally go down, right? And in this case, Samsung just wanted to do something about it, and the retailers would also benefit from it, because they don't only sell Samsung. And that's actually one of the points that I will stress. Maybe that can be interesting for your analysis. I think it's important to focus on the difference between inter-brand competition and intra-brand. And I will explain that in a later slide. I have to go very quick. So I agree, of course, completely with my colleague Pim Jansen that if we look at the economic perspective, we would look at the effects. Economic analysis means look at efficiency. What do these RPMs, or the resale price maintenance agreements, really lead to? Is it bad or good for social welfare? Having said that, I can immediately add an important point, which is that the means to achieve the price coordination matter less for economists. So the fact that the price coordination in this case was facilitated by web crawlers, price comparison sites, and web spider software, it's nice, it's innovative, but it's not relevant, because we look at the effects, right? Once we can see that we have this means to coordinate on price, no matter how, we just look at the effects. Legally, of course, I agree with you, that there may be more difficulties to this. So we have to look at the effects then, right? On consumers, mostly. Of course, we can also look at exclusionary effects, but here we focus on the consumer effects. And I think on the slide it says maybe, that are likely to be negative. Because for sure the prices are higher than they would otherwise be. That's pretty clear in this case. You mentioned some arguments to the contrary, and normally I always bring them in. As an economist, we're often more liberal than the lawyers. I would say, yeah, what about the services, the innovation, the quality? But looking at this specific case, I don't really see it, but it's partially a normative question, and I will explain to you why. Because it depends on the types of consumers. There are different consumers. Some are informed, some are less informed. And for the more informed consumers, this doesn't have any benefits. For the less informed, well, maybe if higher prices leads to better services, they can profit from it, right? Yes, so the effects of a more transparent market generally can go both ways. They can be negative for social welfare, for consumers. As we see, I think in this case, clearly they lead to tacit collusion, more transparency. Sometimes we see it in the other way. More transparency means more competition. But yeah, you have to look at that case by case. Okay, a bit on the economic analysis. I have 2 more slides. I hope I still have 1.5 or 2 minutes per slide. So the economic analysis of RPM, so resale price maintenance or resale price fixing. Indeed, the literature agrees there are different types, price ceilings, price floors, recommended prices. In the end, they're slightly different, but also in their effects pretty much the same. And if we look at the oldest literature and the most economic liberal literature, it shouldn't surprise anyone that we have to look at the Chicago scholars. Already in the 1960s, it was Lester Telzer, you see him at the bottom, the picture, who wrote that vertical agreements, including RPM, can be used to increase total level of sales in the market and thereby increase total welfare. So through the mechanism of sales increase. It prevents free riding, right? How does that work? Well, normally, if you like your retailers to invest in marketing or in pre-sales service, sometimes even after-sales service, it costs them money. But if others could, without doing the same, making the same investments, just steal part of the market, yeah, we don't like that. This is the very reason why in many vertical agreements we try to protect the dealers, right? And RPM can be one way. So it can prevent free riding. In turn, this then automatically encourages dealers to invest in pre-sale services, marketing, and such. That's a story already from the 1960s. And also in the 70s, Robert Borg and Richard Posner, among others, had similar arguments. They focused on the increase of output generated in RPM agreements, while obviously recognizing the anti-competitive nature of vertical restraints. Nobody denies that. In essence, it's anti-competitive. Then something interesting came, I think, also for you, Pim. In the 1980s, the literature on RPM started to focus more on this trade-off that we now face. On the one hand, RPM may lead to higher prices, as in the Samsung case. On the other hand, of course, we may like to protect the level of services, as I just indicated, pre-sale, after-sale, marketing, and such. And what's most interesting is that the conclusion of the literature is that this effect actually depends on the heterogeneity of consumer preferences. In the absence of any free riding problems, and when consumers would be informed, price fixing may only benefit the ignorant consumers. So yeah, it's a bit of a trade-off. Who are we protecting? Those consumers who need the information or who want the pre-sale, after-sale service, or the others? So it's inherently a bit normative, which consumers you want to protect here. This is my last slide, and just stop me, Caroline, if I'm already out of time. But this sums up all of the arguments pro and against RPM, and you can probably check to what extent they would be relevant for the Samsung case. I mentioned some of them, but not all. So if I have 30 seconds. On the left side, we see how RPM can increase social welfare. I mentioned the prevention of free riding, increasing of services, but I didn't explicitly mention that the Chicago school noticed that if there's a double markup, like the retailer sets a margin on the price as well as the producer, then certain forms of RPM, like a price ceiling or a low recommended price, could avoid that. And indeed, depending on the context, I agree with Pim there, sometimes the producer, like Samsung in your example, would want its retailers not to reduce output via price increase, but to fight against it. But I think in the Samsung case, there was a mutual interest to both keep their margins. So that's why I personally think that this argument of preventing the double markup is not so strong here. So I follow the ACM in this perhaps a bit quick conclusion, not having explicitly discussed it. RPM can also be used to protect luxury brands, like in the selective distribution context. Yeah, here you have it, the inter-brand competition and the intra-brand. I think that's very crucial. So the inter-brand competition is likely to increase. So between Samsung and other brands, if you have RPM agreements, even intra-brand within Samsung theoretically could increase. Why? Because a high profit margin may attract other retailers who then also want to sell Samsung products. I'm out of time, I see. Yeah. And there are some other, on the right side, you see how it can decrease efficiency. I tried to stay within 7 minutes, but didn't succeed. So the higher price and facilitation of the tacit collusion. Last point, indeed, whether there's tacit collusion, whether that's what kind of effects it generates, depends again on interbrand and intra-brand. We can maybe discuss that in the break afterwards. Sorry for taking a bit too much time.
Good. Thank you. I will first briefly give Pim the opportunity to respond, and then we have time for a few short questions.
Thank you, Niels, for your very thoughtful comments. Maybe 3 points. The first, and this is something that that I interestingly just discussed with Lisette, who's in the room right now. She's our partner from Nauta Dutiel in Amsterdam. You just indicated that there is a mutual interest by both at both the wholesale level, so Samsung, and the retail level, the retailers, to increase their margins, which means that that eventually for the consumers, the prices will be higher. But I would argue against that higher prices are only possible. So a restriction of intra-brand competition is only possible to the extent that inter-brand competition at the wholesale level is also limited. And that has not been, there's not been no evidence in the case that was specifically the case. So I think that's a very important precondition for being able to effectuate this alleged mutual interest between Samsung and the retailers. Secondly, in your slides, at some point you discuss RPM. The question is, of course, and of course that's a legal question. The question is, of course, is this a real RPM case? The decision is not very clear about it. The ACM just goes back to the text of Article 101, Paragraph 1, Sub A, price fixing. So the question is, and that's why I came with this research, the question is price influencing in this specific case, where there is such market transparency, does it already qualify as RPM or not? And that is for me not clear cut yet. And that to me raises the question: should we then qualify this case as a restriction by object, or if it's not a clear RPM case, should we say it's a restriction by effect? But then it's up to the ACM to prove a restriction of competition, which in my opinion is only possible if you're able to say that there is a restriction of, for example, inter-brand competition, which they haven't been able to put forward. I have to say, I am very interested in the additional argument that you raised on the type of consumer that you deal with. Are you dealing with informed consumers or uninformed consumers? And if you talk about uninformed consumers, then other competition parameters such as advice or whatever could play a more important role. So I'm very, very grateful for that. Thank you, Niels.
Good. Any questions from the audience? Yeah.
Yeah.
Where are you? Can you catch it?
I just had a question for you, Niels, because just to add on Pim's point, I believe there should be at least some market power on the upstream level, but also at the downstream level. And in this particular case, what you saw was that the retailers were actually fairly small players. And that's also why in this example of a vertical, this vertical agreement, the ACM decided not to fine any of the retailers because they were just simply too small. They were new market entrants. They had a very small market position, which at least you could argue whether there is an actual effect on competition, on the broader competition, assuming that Samsung is not the only player in the market. So the market is not limited to just Samsung.
Yes.
But this was a question. Sorry.
This was a question.
Question mark.
Well, I agree. It's more like a statement of facts, almost. No, which is good. What can I say? I think, like I said, in this case, indeed, the retailers were smaller parties. It doesn't change the economic analysis. Again, we look at the effects, and here the effects are that the margins increase for them. It would not have been their own choice, perhaps. Still, for the consumers, in the end, it means that price levels are clearly going up. Market power may have been indeed an important market power of Samsung. May have been an important additional element to go against them.
You could argue if you look at this is the last thing I was saying. If you look at of course the vertical regulation, the vertical guidelines, in particular the new ones, if it is at some point there's a chapter on vertical exchange of price information, and there it stated that in general there is no incentive for retailers to follow, to act on certain pressure from wholesalers unless they have market power. So maybe in this particular case, the fact that there was market power is a very important factor. But if, for example, in another case, there would be less market power, maybe you would have a completely different case.
So let me just say one thing about it, which I think is important because you mentioned it in your response to me about the restriction by object. I would never be in favor as an economist of using restrictions by object, even to RPM, let alone to this. But that's not a legal question. Legally, it may be different.
Good. You will have plenty of time to discuss this further in the break, but now we really need to move on to our next speaker, Professor Maria Teresa Marciolino, who is an associate professor of business law at Bocconi University, and she will speak about the Italian Amazon.
Okay, thank you very much. I would like to use my slides. Those one, yeah, thank you. Oh. Okay, and may I have the remote controller? Here it goes. Okay, thank you very much. So if you see, the title has changed. The title of my presentation has changed. At the very beginning, I wanted to talk to you about the facts of the Amazon case, of the Italian Amazon case, because the theory of harm applied by the Italian Competition Authority was very traditional. We are discussing about the digital ecosystems since 5-7 years ago, about the poor tools that antitrust law can use to fight against them. But still, when antitrust law is applied in the US, in Europe, if you put aside Google Shopping, in the end, the story is always the same. We have a multi-product monopolist working in two markets, the intermediation service of marketplaces and the logistics service for e-commerce, who uses its dominant position to nudge its merchant clients to opt for one of its services in the secondary market. With what effects? That of excluding rivals in the secondary market and charging their higher prices, with the effect on the primary market of excluding other rivals and charging their higher prices or reduce the quality of the service of its marketplace, with an authority that shows that this nudging, this way of putting together two products, does not find any justification, no efficiency gain, no innovation explaining it. So a very traditional, as I was saying, offensive, defensive leveraging theory. But then I said to myself, oh, this would be very boring, quite pedantic. So I read again the decision, and I found out this, that unfortunately you cannot see it because there's that. Well, but while reading the decision, you will find that the Italian Competition Authority qualifies the conduct of Facebook using 3 different labels. It talks about the time, it talks about kind of essential facility, and it talks about a case of self-preference. But while it does it, it doesn't show coercion. It doesn't discuss in details about the essential nature of Prime and the other functionality that were made conditional to the preference for FBA. And it didn't talk about the conditions of Google Shopping that should frame self-preferencing. So is there anything wrong with using so many labels for the same conduct? Is there anything wrong with the lack of evidence on coercion, on the essential nature of some features, and on the inconsistencies between the Amazon decision and the elements on which the court of first instance, focused in Google Shopping? Now, you may answer these questions in 2 ways. You can say, yes, Houston, we got a big problem here, because if we consider the classes of exclusionary conduct as if they were legal characterizations, then if you don't show the liability conditions specific of each legal characterization, you have not proved your case. So you fail. And if you got one conduct at three different legal characterization altogether, well, you are creating legal ambiguity, at least. But let's try to answer another way. No, if you believe that we should enforce, as economists like to say, the effect-based approach to interpret Article 102, you can argue that the only legal characterization that matters when we apply Article 102 is that the abuse is the notion of abuse based on the analysis of the effects. And so you can argue that any conduct producing the same effects in terms of exclusionary effects, anti-competitive effects against pro-competitive effects must be judged in the same way. It means that it must have the same chances of being prohibiting or accepted, regardless whether it appears as a tying, as a self-preferencing, as something else, less exclusive dealing, essential facility. Now, for today, I will support this thesis. I will support that we have to go for an effect-based notion of abuse. Why? Because this is what the COJ, the Court of Justice, has said. In post-Denmark, the court has said clearly, look, dominant firms are allowed to show that their anti-competitive effects, their exclusion, the effects of their exclusionary conduct can be offset by innovation and by efficiency gains. And in Intel, the court repeated this statement, and in addition, it says, and why do we do that? Because we don't want to use Article 102 to shelter inefficient, obsolete competitors of dominant firms. But you could say, no, I do not agree. Why? Because the list of conditions that we associate to tying or to essential facility guarantee us or ensure us legal certainty. Well, but we can ensure legal certainty also doing the analysis of the pro-competitive against the anti-competitive effects. So the elements, we still have plaintiffs obliged to show some elements. And then you could argue there are other principles to be protected by using 102. For example, think about self-preferencing. Somebody could argue self-preferencing exists not because we want to fight against exclusion, but because we want to fight against discrimination. And we want to create a kind of equal opportunity right or equal opportunity duty for dominant firms. Well, I would not agree with this, but still, this would be a matter of politics or policy and not a matter of law. Still, if you think about self-preferences not as an exclusionary conduct, but as a pure discriminatory conduct, what I was saying doesn't work, because what I was saying that the notion of abuse for exclusionary conduct should be based on the effects on their effects is linked to the fact that they are exclusionary, to the fact that we don't want to live in the market those that are obsolete or not inefficient competitors. So what? You could say, well, so what we do with coercion? What we do with the essential nature of the claimed input in essential facility cases? Well, we can still keep them with us, and we consider them as factual elements on which, or on the basis of which, we assess exclusion. So we can use essentiality, we can use other parameters to understand whether the exclusion takes place, whether it is likely, very likely or not. But we can use those parameters together with others. But when we say that there are not elements of the legal characterization, we say that you don't fail your case if you don't prove it, if you don't prove it. Thank you.
Thank you very much for this enthusiastic presentation. Yeah, I expect that is Mr. Thomas Tombal, our respondent. Good, go ahead. So first, brief introduction, I forgot. Mr. Tombal, Thomas Tombal is a postdoc researcher at Tilburg University. And now he has been able to settle in.
Thanks a lot. Thanks for having me. And thanks to the organizers for allocating me this paper, because what's great is that it's short, it's to the point. So it's like a dream to discuss on, because I think the question you asked is extremely relevant, especially today where we see that competition authorities and Commission first are struggling to establish cases, 102 case against these digital actors, which have practice that look like brick and mortar stuff, but it's not exactly brick and mortar stuff. It's, is it self-preferencing? Is it essential facilities? Is it tying? It's a little bit of everything. It's a bit complicated. And so I really think like the core question that you asked, like, should the form matter? Or at the end, should the only thing that matters is there's anti-competitive effects and be objectively justified? I think it's a very fundamental question to ask. I would agree with your point of view. I would say that we shouldn't be too formalistic in the sense that, this doesn't meet essentiality, so it's not going to work. So, but of course, it creates this uncertainty that you're mentioning, but it doesn't necessarily bother me because you always have to find a balance between uncertainty and flexibility. And it's almost a matter of policy to decide, whether you want to go more on the side of flexibility or go more on the side of certainty. I think with these big tech players, we tried the side of certainty. It's not really working. So maybe we can try to move a bit more towards flexibility. So maybe some general comments. I don't know if you saw that Giorgio Monti also wrote kind of a piece about the Google case where he has a part of it, which is also about, does it actually matter, this classification, it's on SSRN. And I think there might be some other papers out there that deal with this more general idea that it might be worth exploring. But I quite like this idea that, if I'm putting myself in the Commission shoes, I'm like, okay, this conduct could be A, B, C, or D. And I kind of have some leeway at cherry picking, for me, which one is the most interesting. For example, you see in the Google shopping, they were like, well, essential facilities, I definitely do not want to go there. So I'm going to try to create this whole new theory of harm, self-preferencing. And it worked and it has been validated. We'll see if the ECJ eventually validates it. But I like this approach because, the defense is going to do exactly the other way around. They're going to say, they're going to cherry pick too. And they're going to say, no, this is an essential facility case. We need to rule it as a. So I'm kind of okay with that because, this is something we have in criminal law. I'm a public prosecutor, a crime has been committed. Do I go for murder? Do I go for assault with intent to hurt, but not necessarily to kill? Because of course, depending on what you go for, what you qualify, the burden of the proofs is going to be different. And it's a very lawyer exercise to say, okay, what's the qualification I'm going to go for? And what am I going to meet? So I really do think that it's interesting. And maybe you can relate it a little bit more to like the idea of the rule of precedent and differentiating in that you have in common law countries, where you would say, well, we really look at the facts. And, if these facts don't exactly look like Bronner, then we don't do Bronner. If the facts don't exactly look like Google shopping, then we don't do the conditions of Google shopping. If the facts are exactly like Bronner or exactly like Google shopping, then I have to do exactly like Google shopping or exactly like Bronner. And that's where you keep some form of centrity. But as soon as you manage to differentiate the case, and that's the whole game in common law countries, to say, well, this precedent, it bothers me, so I'm going to frame the facts so that it doesn't match those facts. I think if the Commission is allowed to do that, that would be fair, I think. So yeah, maybe you can even strengthen your argument even more by relating to this like common law idea. Of course, we're not like the EU is not really common law, but there's some inspiration there. Maybe it's just an idea that this shift might make sense. And I will finish with maybe a further thinking comment, because when we talk about self-referencing, of course, we think DMA. And I would think, but I would be curious to hear what you think about this, that actually, to me, the DMA takes exactly the opposite way. So what you're suggesting is that competition law, we should go effects-based and not so much form-based. And the way I read the DMA is actually, it's 100% form-based, and effect-based doesn't really matter. You have a list, you have to do it. You cannot really prove that there's a justification. You cannot really prove efficiency. There's really a narrow margin for discussion. You can't self-preference, end of the day. So I'm curious to see, if you agree with this vision that they're basically completely opposite. So they're not as close as some people might think at first sight. And second, how is this going to work then moving forward? Like the coherence between the two. Is the commission going to privilege one over the other? Is it going to be dependent on the cases? How do you think this articulation is going to be? So I'll stop here, but it was a very interesting read, and thanks a lot again for that.
Thank you a lot. I will answer first your last question, the relationship with the DMA. I totally agree with your representation. The TMA is a piece of regulation and it supports a really form-based approach. I think that in this way, national competition authorities and even the commission may find more room for themselves, just because they could leave to the DMA what is exactly written there and try to work around it for looking at the other conduct that in DMA have not been crystallized yet. Because the real problem with DMA is that now we know those conduct and now we forbid them. But who knows about the future? And the commission said, well, I know that. Indeed, in future, I will revise the list of legal conduct which are unlawful. Yeah, okay. Meanwhile, before the new revision, probably antitrust law can step in and say, look, I don't care about the form. As long as you produce more anti-competitive effects than pro-competitive effects, you are guilty. you are violating. Yeah, but so thank you for your suggestions. I will work also on the comparison with the common law systems, because there are this way of the idea that claiming one thing instead of another gives you more chances to succeed or not is very, very deep in the culture, in the legal culture. I made an example of predatory innovation against refusal to deal against tech tying. For American lawyers, predatory innovation can never be proved, whereas maybe tech tying, yes. So every time they have a technological integration, they go for tech tying and they do not do predatory innovation. But yes, thank you very much for your suggestions. Thank you.
Thanks to you both. Any questions from the audience? Yes, first the person entirely in the back.
Rock, paper, scissors?
Yes, please use the microphone so that
Can you hear me?
people who are
that's great.
using Zoom
Okay.
can also hear you. And please first state your name and affiliation.
Okay, I'm Oscar Borgogno. I'm from the Bank of Italy Research Center. Thank you so much for your presentation. I found it kind of fascinating. And I'm just wondering, what do you think about the fact about this hypothesis? It seems to me that what we used to know as competition scholar, the big distinction within 102 TFU between per se prohibition and effect analysis prohibition, that was kind of the two pillars making up 102 analysis, have now been destroyed by the case law analysis over the last years, because effect-based analysis got full priority, and making your point, you really aligned with that. We saw that the European Court of Justice in the last cases really focused on the effect-based analysis and really put the accent on that. But on the other side, with the DMA, basically, we saw a comeback of the per se prohibition just with another name, which is by means of regulation. So at the end of the day, basically what we used to know as a framework that was completely within the umbrella of Article 102 and maybe was more consistent, now basically split between regulation, which is really formalistic, as you said, and then effect-based analysis that will remain within the realm of Article 102. Do you agree with that? And do you think this is an improvement comparing to the past scenario or not?
Should I answer this immediately or after this? Okay, thank you. Thank you, Oscar. Well, let me clarify one thing. When we talk about supervision, when we talk about per se prohibition in antitrust law, we don't talk about form-based prohibition. Price fixing are per se prohibition because we assume that they will always produce anti-competitive effects. So we have a shortcut, but still we have an effect-based approach there. Because of economics. Now, I agree with you. The DMA, via regulation, has imposed us some form-based violation, and I cannot do anything to forbid it, to prohibit it, to block it. What I can do is to keep antitrust law as genuine as possible. And so try to remark that antitrust law must be effect-based, whereas now regulation will be very form-based.
Okay, second question, there was a second question.
Thanks. Hi, feasible student from the University of Leuven. So I would agree that that we should go for an effects-based approach, and I think that is the case certainly at EU level. It has won out with one of the last examples being tying, which used to be more or less per se, is now firmly effects-based since Microsoft. But should we not still distinguish degrees of effects? I think most abuses conform to let's say a standard effects test where you need to prove a likelihood or capability. But some abuses, or at least one, refusal to supply, has a bit of a higher bar, this indispensability and a related elimination of all competition. And I think there's some good reasons for that. The freedom of contract argument, the incentives to invest argument. So at that point, does the qualification still matter, at least to distinguish this very abuse from almost all of the others, or should we all throw them in one basket?
Thank you for this observation. I totally agree with you. I'm still working on my paper, so I don't have finished anything yet. I do believe that there are cases where the exclusionary effect is higher and cases where the exclusionary effect is marginal. As well as there are cases where we don't want to, as we take a policy decision and we say, look, even if there will be exclusionary effect and significant ones, we don't care because we want to protect the property right or we want to protect the freedom of contract. At that point, the qualification does not help you understanding what is right and what is wrong about exclusion and the structure and the competitive structure of the market. That qualification derives from different principles that have nothing to do with the protection of competition, but with the protection of the property right, with the protection of the freedom of contract. Maybe in the end, I will state something obvious. But the point is, what are the roots, the ideological or ideal roots of the way we do, of the way in which we do things? Why do we raise the bar with essential facility? I know in order to protect the incentives to innovate, I know all the stuff. And when we have exclusive dealing, we are very low, sloppy. Whereas every exclusive dealing implies a refusal to deal. If I made an exclusive dealing with him, he will refute his outlets to her. So every exclusive dealing includes a refusal to deal. So why do we have different standards for the two? Every tech time implies a refusal to deal. Every incompatibility implies a refusal to deal. I'm not the first to say it, okay, but I think we could work on it.
Thank you. Yeah.
Maciej Janik, the University of Łódź in Poland. Just one comment, because I can see, and I see it completely differently, maybe, or maybe there is no difference, that the DMA is compared to competition law, whereas those are completely two different kind of types of law. One functions ex ante, one actions ex post. So I don't think we can compare it, and that we can use the sort of a position that we had in a form-based analysis under competition law, which should be differently, but it was, and I agree that the effects-based should be the way to go, but apparently it was concluded by many different states around the world that competition law is not dealing very well with the problems that are generated by digital platforms. And hence, not only Europe, but many other jurisdictions have introduced some form of regulation, which has a completely different function. So we cannot say that it's, you know, like spoiling competition law, because we are talking about completely different regimes, which have a different, even the old, I mean, the older sectoral regulations that have been treated differently, to the extent that fines that were imposed by regulators, the sectoral regulators, were treated as something different than fines imposed by competition authorities. So I think, you know, we can criticize whether it was necessary, but at this point, since the legislation will be introduced in some form or another, I think we cannot say that this means that we should not analyze the regulation under competition law. I mean, the DMA. That's just a comment.
Yeah,
Thank
you're
you.
totally right. Totally right. I didn't want to say it. I agree with you. The DMA is a piece of internal market law. It's not a piece of antitrust law. So there are two different pieces of law. You know, sometimes you put them together because the kind of practices that have been listed there come from the antitrust world and our antitrust cases, but you're totally right.
Yeah, there's a question there. Yeah.
Thank you, Pratiksha Ashok, UC Louvain, PhD researcher. My question is more of a comment, because as a common law lawyer, I wanted to ask your opinion about two things. That India recently introduced its competition law amendment bill, which would later become an act, which recognizes self-preferencing and the impact of self-preferencing by platforms. I wanted to ask you whether you see a difference, not necessarily in civil law, common law countries, but in the global north and the global south, in terms of developed and developing countries, and the way that competition authorities in different jurisdictions address self-preferencing in a developed union versus a developing union, where focus is more on innovation and smaller businesses rather than larger businesses and platforms. Thank you.
Well, sincerely, I'm not so educated to answer you at a global level. In my experience, I noticed this, that when it comes to the duty to share or to the obligation of monopolists to work as if they were, I use a US expression, the nannies of competitors, your economic tradition matters a lot. When I have taught in the US and asked them, my students, what do you think about this company, which is a dominant firm in your market? It deserved it. It was good enough to be there. When I asked to my Italian student, they say, well, it was a state-owned company. It grew up because of taxpayers' money. Now, I do believe that our approach toward the duty to be fair in relation to competitors somehow depends on how we perceive these big companies, as if they deserve what they have, or that if somehow they don't. But then I don't know anything else. I'm sorry.
Sure. It's okay. Thank you.
Is this on? Yes. I asked for a 30 seconds reflection on the comment that was made in the back, which I liked a lot. The distinction between the ex-ante regulation and the ex-post competition. The way in law and economics, so economic analysis of law, we approach instruments like the DMA. Is this actually a response to market failure? The market failure here is let's say, a market power that originates from economies of scale and such, network effects, all of that. It's like a natural monopoly. Basically, like we need to allow the natural monopoly to exist, but to regulate it. We need to regulate the price or quality, like in the utility sector. So I agree very much with that perspective.
Good. Thank you. Very interesting, but we need to move on to our next presentation that will be online by Gentian Skara, who is a full-time member of the Department of Law at Beder University College. Gentian will speak about the transposition of the ECN Plus directive in Albania as an EU candidate country. Gentian, go ahead.
So, do you hear me?
Perfectly.
Okay, thank you very much, Caroline. And sorry for not being there, but due to the plane cancellation, and I hope that I will join tomorrow. So, my paper presentation relates to the transposition of the ECN Plus directive in Albania as an EU candidate country and the impact and challenges of the Albanian digital environment. So basically, my research questions are firstly to analyze the transposition of the directive in Albania as a candidate country, and secondly, to discuss the role of the Albanian Competition Authority in the digital market. The paper that I have submitted is structured in 5 sections. The first section provides an overview of the enforcement of the EU competition rules and is focused mainly on the public enforcement, starting from the Regulation 70 to Regulation 2003. Then I discuss the ECN Plus directive, and I analyze the legal base, why the Council and the Parliament opted for the directive instead of the regulation, as was the case of the Regulation 1/2003. And then I provide some main novelties introduced by the directive. Then I move to the Europeanization of the Albanian competition law, which I prefer to call as Europeanization, which is the obligation of Albania to approximate its domestic law with the EU law in general, and more specifically to the competition law. Then I deal with the transposition of the directive and the role of the competition authority. When we discuss for the enforcement of the competition law, since the 1962, the Regulation 17 centered the Commission a powerful role in the enforcement of the competition rules. And after that, during 19, as the European Union was enlarged, it was needed to design a new enforcement system. And then we have the white package, white paper in 1999, which is called as modernization package, which later was introduced as a Regulation 1/2003. As we know, the Regulation 1/2003 abolished the system of the precautionary notification, and most importantly, it provided power to national competition authority and national courts to apply EU competition law. So basically, what Article 101 and 102. And another novelty of the Regulation 1/2003, it was that it established a cooperation between the Commission and national competition authorities, which which in 2004, it was established as the European Competition Network. When we come to the need of why the Council and the European Parliament approved the ECN Plus directive, we should say that in the case of the Regulation 1/2003, this regulation provided just the substantial rules of the competition law. So basically, it provided that all the member states have to introduce the substantive rule across their territory. Whereas the procedures and the powers, competencies of the national competition authorities were left aside. For this reason, in the assessment made in 2014 and later on, the Commission noted that there is a need to introduce a legal measure, even in the case of the harmonizing the procedure and also harmonizing the powers of the national competition authorities. And here we come to the ICN plus directives, that the main rules are first to introduce rules regarding to independence and resources for all the national competition authorities. And I must say that these rules are introduced at a minimum level of harmonization between all member states. Secondly, it provided powers to the national competition authorities to effectively enforce EU competition rules, then empowered national competition authorities to impose dissuasive fines, and also it provided rules for the governing of leniency programs. Leniency programs, until the ICN plus directives, was regulated mainly by the soft law. And for the first time, we have a legal binding instrument. And the fifth novelty, it relates to the rules governing mutual assistance among the national competition authority. The legal base of this directive is both Article 103 for the internal market and 140 for the 103 for the competition rules and 140 for the internal market. And in this case, the Commission opted for a directive instead of regulation, because if we see now how many member states have transposed the directive, we will notice that there are 5 or 6 member states that still are about 2 years after the prescribed time have not transposed the directive. And I'm speaking for the EU member states. When we come to the Europeanization of the Albanian competition law, since 2009, we have an agreement with the European Union and the member states to called the Stabilization Association Agreement, which is a mixed agreement falling under Article 217. And basically, Article 70, paragraph 1, laid down the obligation of the Albania to approximate its existing and future legislation in compliance with the EU acquis. And when we see later on the effect of the EU competition acquis, we will see in Article 71, paragraph 2, that competition law, EU competition law is applicable even before the accession of Albania in the European Union. Because, so I'm reading paragraph 2, says that any practice, which is practice related to agreements provided in Article 101, shall be assessed on the basis of criteria arising from the application of the competition rules, in particular from the treaty provision of the competition rules and the interpretive instruments adopted by the community institution. So meaning that Albania Competition Authority has to refer to the EU competition law and to the practice of the Commission with regard to the application of its domestic legal system. Such approach has been maintained as well by the Albania Constitutional Court and also by other courts of the accession countries, such as Macedonia, Bosnia-Herzegovina, Serbia, etc. Then, in the case of the transposition of the directive, we are in the phase that we are trying to open the negotiation, and the negotiation goes that for every chapter has to be established a working group to approximate its domestic legal system. And in the case of the competition law, it's the Albania Competition Authority as a responsible institution. And I must say that Albania competition law is fully in line with EU treaty competition provision, Article 101, 102. And furthermore, the Albania competition law has adopted several guidelines and Commission notice to further align the Albanian competition law in line with the EU competition acquis. In the case of the directive ICN plus, Albania competition law transposed this directive through a guideline. And our analysis in the paper demonstrate that such approach is mistaken. Because if we see the sources of the domestic law in Albania, the guideline adopted by the Albanian competition law does not have any legal binding effects, meaning that it must be only for a point of reference by Albanian competition law, but you cannot rely as a legally binding act in the court. Secondly, what is noticed, and this is a practice from the Albania competition law with other directives, regulation, notice, guideline, is that they adopt a literal transposition of the EU laws or soft laws in the area of the competition law. With some exception, instead of referring to the EU law, they refer to the national law. And this is understandable because we are not yet part of the European Union. And in the case of the directives, I have shown in the paper that about 95% of the provisions of the directives have been implemented in the guideline. And as I mentioned, the guideline does not provide any legal binding effects. Also, when I compare to the other, how the EU member states have transposed the directive, we see that other EU member states have transposed the directive through legally binding act, either introducing a lex specialis or by amending the current legislation. So in our situation in Albania, in order to have a proper transposition, we have to amend firstly competition law or to introduce a specific legislation in order to empower a competition authority to enforce properly competition rules. Second issues that I discuss in our paper is the role of the Albanian competition authority in the digital market. So digital market in Albanian competition vision came in after 2019 or I think 2020, and we see only in the speeches of the head of authorities rather than in its application. So Albanian competition authority has been established in 2004, and recently we have about 19 decisions per year, and of course is distributed. But when it comes to the digital market, we cannot find any decision. And we must accept that Albania is not as much developed as the European Union member states, but still there are some opportunities for the Albanian competition authority to interact in the digital market. And the main problems that we have identified in our paper is that, firstly, there is no existing competition law or Albanian competition authority bylaws to address competition issues arising from the digital platform. So when we see that in the EU level, also and in EU member states legal system, they are introducing pieces of legislation to regulate digital market and competition issues. Whereas in Albania, such issue is not discussed. We see only, as I mentioned previously, rhetoric speeches. Secondly, there is a lack of understanding of how digital market operates in Albania. And here we had, in the Albania Competition Authority, we have two missed opportunities. When Albanian Competition Authority investigated bank sector, and it noted that the bank sector has developed digital services and so on, but it did not analyze further what impact this digital service might have with the competition. The third problem which we have identified is the lack of appropriate tool to analyze the anti-competitive practices, and the fourth is lack of human resources. Currently, in Albanian Competition Authority, there are employed around 30 or 35 people, and persons which have technology knowledge, and so in order to analyze the digital market and so on, there are only 2 persons. And I do believe that there are not enough. And thirdly, they have to increase the number of the persons dealing with the technology, because they have to act in a timely and in effective way.
Good.
As a conclusion,
conclusion.
Yeah,
Good.
as a conclusion, firstly, we didn't implement properly the directive, so we still have our own problems. secondly, we have to introduce by a legally binding act, and this might be as a lack of knowledge how to transpose the EU legislation into our national legal system. And the third one is that the Albanian competition authority should be equipped with sufficient number of qualified staff and sufficient financial, technical, and technological resources. So this was my presentation. Thank you very much.
Many thanks, Wolfgang. In view of time, we immediately move on to the response by Maria-José Schmidt-Kessen, who is an assistant professor at the Legal Studies Department of the Central University in Vienna and an ex-student of Maastricht University. Yeah.
Yes, exactly. So first of all, thank you so much, Cauffman, for organizing this terrific conference. And so I graduated in 2010 from an LLB in European law at Maastricht University. That makes me feel very old today. And it's also very nice to see the Brussels campus for the first time because it didn't exist back then. So that's great. Now to the paper. Thank you so much for this paper because it's really something that is on the periphery, I think. What is going on in terms of competition law enforcement in countries that are bound by the stabilization and association agreements and that are kind of trying to get their laws and their practice aligned with European standards without being inside the European Union. And I think there is so much fertile ground to compare what's going on in CEE countries inside the European Union when it comes to the transposition of the ECN Plus directive and what's going on in non-EU CEE countries that are bound by SAA. So when I look at the paper, and I think I'm just summarizing, there's two arguments, right? So there's first the argument that because of the SAA, Albania needs to transpose the ECN Plus directive. And the argument is the competition authority has the competence to do so, but it did it wrong. It did it in contravention to the SAA and to Albanian law because it adopted a soft law instrument, which it shouldn't have done. The second argument is the Albanian competition authority is doing nothing in digital markets, right? Those are the two, and that's wrong, and there should be a change, and you propose some solutions. So my first comment is that I wondered how the two connect. Is there a link between the transposition, the wrong transposition of the ECN Plus directive on the one hand, and this non-action on digital markets? Because that wasn't clear to me from the paper, and here's a hypothesis how I see a connection. And that's Article 4.5 of the ECN Plus directive, which should give national competition authorities the power to set priorities. And the idea is then that the Albanian competition authority is not setting priorities as it should. And my question here is that correct? Because after all, setting priorities is a matter of allocating scarce resources. And the first question is, fine, there are no resources at the moment in terms of capacity in the competition authority to go in and check whether there's any infringements in digital markets. But do you really need to increase staff numbers for that and hiring of experts? Or is there other ways, for example, twinning, kind of entering into partnerships with competition authorities elsewhere that are actively enforcing competition law on digital markets instead of, kind of going the costly way of allocating resources? The second paradox that I found and that I would love to hear more is how independent is the Albanian competition authority? Because in Poland, the ECN Plus directive hasn't been transposed, and those that are observing the situation there are worried because the national.
Okay, welcome everyone. We're a few minutes early, but I hope this is not a problem because it gives us also a few minutes more to present or discuss. So welcome everyone to session 2 I was already in the first session, but just to be sure, I will introduce myself briefly. My name is Niels Philipsen. I'm one of the co-organizers of this event, and I'm affiliated both with Maastricht University and Erasmus University Rotterdam, with a background in competition economics, but now doing law and economics. I've been doing that for many years. So now we have a session which is really about the economic perspective. We already had some economic discussions before, and we will continue to have them also after this session, undoubtedly. But now we're really going to focus on particular types of conduct, exploitative or exclusionary conduct. And of course, we are still in the digital world. And we have a keynote speech and then 2 presentations. So I will, for now, just introduce the keynote, because that's what we are going to do first. In fact, our speaker barely needs any introduction. We are very happy to announce that Daniel Sokol is here. He is the Carolyn Craig Franklin Chair he has in the Law and Business at the USC Gould School of Law in Los Angeles, of course, while he is also affiliate professor at the USC Marshall School of Business. As we know, I guess many of us know, he's among the top 10 most cited antitrust law professors in the last 5 years, and he has presented his work to competition agencies around the world and at many other places. So we're happy that he will present his work to us today. So I will not take any more time away from your presentation, Daniel. So please take the floor and share your presentation if you can. Yes, we all see that. So please go ahead.
So I want to say thank you very much to the organizers. Thank you everybody else for having me here. So again, my primary appointment is at the law school. I have a secondary appointment at the business school, also part-time. I work at White & Case, where I do some legal work, both for and against tech companies, for industry associations, and in an unpaid position, I also am academic advisor to the U.S. Chamber of Commerce, which means technically, I guess I represent every company. But with those disclaimers aside, this presentation is based on a handbook chapter that I did for the team at Leeds that are putting together something on abuse for Elgar, and really I tried to come up with for this presentation to sort of what motivates the thoughts on big data. What have we actually seen in the cases, and is there a way forward? The answer in short is the understanding that we have in competition law is a bit skewed. So we have theories, but we don't actually oftentimes connect theories to the empirics. And here I'll explain that we need a broader sense of empirics. So in a separate project, I looked at both the FT50 and UT Dallas rankings for top journals, and I even added the primary IO field journals, RAND, Journal Industrial Economics, and IJIO, plus Journal of Law Economics and Organization, Journal of Law and Economics. When you add all those journals together and you look at the empirical work on platforms, so this is only in top journals, you end up with roughly 800 articles that have been published in the last 20 years. Again, empirical. So 2 things emerge from that. Number one, not more than 15% of the empirical literature is in economics. So if you're only looking at economics, you're limited. Most of the economics work is theoretical. But there are other fields that are very much what I'd call economics adjacent information systems is where actually you have the most of this empirical work, but you also have it in management / strategy, in marketing, to a lesser extent in finance, and all of a sudden you're seeing work now in operations, largely with natural experiments. So I say that largely because it's hard to come up with law and policy implications and recommendations if you don't have a good sense of what's out there. And it turns out collectively we have failed in really identifying what's out there, integrating that into our theoretical models and also our legal tests and presumptions. So I'm going to first motivate the talk, then I'm going to give you sort of where the case law is and is there a way forward? And the answer is yes. And this is also where, in a true academic form, I say, I am mistaken. In 2016, I wrote an article said, based on what we've seen so far, there's never going to be a big data type of abuse. I modify that now to say, no, I think we are, under certain parameters, it is possible. And I explain where that is likely. And having told you that it's an econ adjacent fields, let me also tell you, I spent a semester as a visiting professor in an engineering department when I was at the University of Florida. And then all of a sudden I actually saw that all the assumptions I had about data, were a little bit too coarse, and there was much more subtlety. And I suggest to everyone, particularly law professors, right, spend time talking to engineers / computer scientists, because it turns out that's incredibly useful. So with all of that, I'm going to get to the actual presentation now. So we know that digitization is transforming society. Essentially, what we had, say, 10 years ago was a set of companies that were early movers in this digital transformation, using AI to do better prediction. These companies are GAFA, but certainly not limited to just GAFA, but those were among the early movers. At this point, there isn't a part of the global economy among large companies where you aren't seeing digital transformation across so many different areas. I have here just a number of areas to give you an example. And by ESG, what I mean is you can use AI to better track your supply chain, to also have better compliance with regards to a number of ESG factors, both internal to the organization, also dealing with third parties. I think the others are fairly self-explanatory. So the reality when people say like, oh, there's some kind of lack of data, data is the new oil. That's not quite true, because, oil is not everywhere, but data is everywhere in everything that we do. Much of data, we just shed constantly. This is what I mean by exhaust data suppliers. So for example, a modern automobile that you buy today has some 3,000 to 4,000 sensors in it, producing lots of data. How useful is this data? That's a little more interesting. But particularly even if you're in a business to consumer business, whether it's e-commerce or some kind of social media, in fact, it's relatively easy to get data. If you don't have the data, you can get it relatively easily, because you have, for example, third-party data resellers. And how do we know how many there are? Well, as Professor Rubenfeld knows, having taught in California for so many years, California has, as of last year, a requirement that if you are a data broker, you actually have to register under certain parameters with the state. And it turns out that there are 242 registered data brokers, including some very large companies. And so it's fairly easy to get data sets. It's really not the data that matters, it's what you do with it. Very rarely, and this is where my own thinking has changed, it's not impossible, but very rarely is data unique. Where it is unique, sometimes it may be for a regulatory reason, or sometimes it may be because you really can't get it through other sources. Normally, you're going to see that further upstream rather than downstream. I worry very little about end consumer data. It's how you put data sets together. So what are you using it for? That's what matters. But the reason why we care about data is largely because we have a related concern about privacy. So I think a lot of what drives concern about data is really not a pure competition issue, but it's about privacy. And so again, here there's a long literature in the economics of privacy. There's also tremendous work done both in marketing and information systems, including really cool empirical work. And on the marketing side, I don't just mean IO style marketing. I also mean a lot of behavioral psychology type work. So it turns out there's a lot of heterogeneity in privacy. You know, the settings we use, et cetera. So the way I try to explain this is, we like to say it varies by country and over time, and also depends how we frame it and the particular context. And all of this is a set of cost-benefit trade-offs that we make as individuals and as society. So we're told in the United States we care about privacy, and yet we are in season 12 of The Real Housewives of Beverly Hills and season 16 of The Real Housewives of Orange County. You know, do we really care about privacy? So when you look at studies, and the most recent cross-country study that I've seen was in the Journal of Competition Law and Enforcement, wonderful journal that Pablo Ibanez-Colomo edits, and it was by Jeff Prince here at IU Bloomington in the United States. And what he actually finds is that Europeans take privacy much more seriously than anywhere else in the world. And for those of you who are in Belgium today, you say, well, of course we do, but that's not how the rest of the world tends to view privacy. We have different privacy parameters. There's also some really wonderful work on platforms and privacy and competition that Pinar Ahmed has done, some survey evidence that's just out in the Virginia Business Law Review that also explains some of these things that show this heterogeneity in these kinds of settings. And I think this matters. Why all the focus on abuse type situations? Because it turns out, you know, we have this privacy paradox, as I mentioned. And why does that matter? Because we get conflicting goals. We're told we care about privacy. We know that somehow privacy interacts with competition. The reality is sometimes it interacts in the same way. Sometimes the two are at odds. But the idea is somehow we have large companies, people don't know what they're consenting to, and therefore we should break up these companies. And I think the world is a little bit more complicated than that, but this public pressure is incredibly real. And because it's real, we think about our competition tools and we ask, can we actually use competition law as a mechanism to deal with privacy, which is really a concern about data, who owns it, who uses it, who has access to it. And so I'm talking about law, I'm not talking about regulation right now. So I'm talking about enforcement. So ownership in itself is not anti-competitive. It's really what you do with it that matters. And that tends to be case by case. And some of the cases that we have involve large tech companies, but some of them actually don't. And like so many of the great competition law cases involve companies sometimes that you've never heard of. But you have great facts and you can create great law. So we have certain questions that we ask from a competition law perspective, right? We have to figure out what's the market, and is there the unlawful exercise of market power? And a lot of times, if there's some sort of data monopoly, if this is the claim, are they creating barriers to entry? So the answer is it depends. There's also a related area that we're told that data is an essential facility. Does that actually seem to exist in reality, or is this, academic fancy? So what we normally have is we define, when data is a product, then we do traditional market analysis. When it's an input, we've had those kinds of cases too. The reality is, both in Europe and the United States, data as a product and data as an input, much of this has been in the merger context rather than in the conduct context. This is changing. You do have some cases, and I'll discuss them momentarily. But I'd say, at least on the merger side, to the extent that we can extract the thinking and apply it to the conduct side, it's a fairly standard analysis. So given what we now know empirically about data, most data is widely available. I say most. Why? If there's some kind of regulatory barrier, for example, healthcare, or for example, a wonderful case that the French Competition Authority brought in 2014 against Suez, where, as a result of them being a regulated monopoly, they had unique historic data that competitors didn't have. These kinds of regulatory barriers, unique. One could imagine certain kinds of upstream sensors for industrial use, manufacturing. There might be some truly unique data there. Same thing potentially in agriculture. All of this is upstream. Downstream, we do not have this kind of situation. Empirically, we know it's relatively easy to get data. Just people are shedding data constantly, or frankly, there's plenty of these data brokers who are selling data sets. So for example, if you look at your Netflix and you look very carefully at the very long disclosure, they don't say that they don't sell to third parties. How much do we sell to third parties? How much, most companies don't break that down. So we don't know what percentage of revenue comes from that, but from some companies, we can impute a lot based on, for example, cookie use, although, as cookies are being phased out. In most cases, therefore, data is not going to be unique. Therefore, it's not like oil, and it's non-rivalrous. Just because one person has data doesn't mean somebody else couldn't use the same data. And we now know empirically that you don't need to match the scale of data to compete. One of my favorite examples here has been in the online dating app situation. There are actually a lot of papers on online dating apps, which suggest that academics, need to date more. But it turns out, if there was some kind of data monopoly, Match.com, which was the dominant player in the early 2000s, would still be dominant today. It wasn't. Every new dating website to get scale needs data, and yet how is it that we have all kinds of new apps that of which the most interesting today, I give you two examples. One is Tinder. The big innovation there is something that we've been doing for probably thousands of years, some kind of binary scale in our mind, yes or no. What yes or no means, I'm going to leave to your imagination. But once they have some kind of swipe left, swipe right, all of a sudden, lots of people go to that website. But it's all about differentiation, because the other big success story is a dating app called Bumble. Bumble, the innovation there is we made women who get lots of creepy requests on dating websites, say they have to make the first ask to the men. And that seems to have really differentiated them and got them a lot of usage. They didn't need data for that, just had a new idea. And so data may not be necessary. And there's actually a lot of empirical work, believe it or not, beyond dating, but I just find dating connects to so many people. So is data essential? The answer is very, very rarely. Where it is, it tends to be historic data or regulated data. Healthcare would be one of those areas that comes to mind. And by health, I mean the heavily regulated type health data. It turns out, though, in the United States, for something to be essential is quite hard. And that's what I'm going to get to right now. If you look at refusals to deal, and I really do note that these are refusals to deal cases as opposed to essential facilities. And this is a common mistake that people make. For example, in the lower courts, there was an essential facilities claim made in both Ottertail and Aspen skiing. The Supreme Court purposely did not look at the essential facilities claim. They did not decide it on those grounds. So people try to say, actually, these are essential facilities claims. They're not. They're related, but it's not the same. And so we have a sense of what essential facilities looks like in the lower court. And what's interesting, by the way, about all of these, the one that sort of the classical case, terminal railroads, was actually a collusion case. It was not a single firm conduct case. That if you look at, and Associated Press was really a group boycott. Lorraine Journal, Ottertail, great cases. These are your traditional single firm cases, but these are not essential facilities cases. When we look at the modern US cases, essential facilities is all but dead, and data doesn't seem to fit within these kind of parameters. When you look at cases now in the United States that have been decided, so Authenticom was a data scraping case, section 1, but they make the essential facilities claim, no. By Facebook, I don't mean the current antitrust case, I mean decided cases stemming from the Cambridge Analytica that were decided in federal court, and the essential facility claims are removed. HiQ Labs versus LinkedIn, you'd say, oh, this is another big tech case. LinkedIn, owned at this point by Microsoft. Turns out, though this case is sort of still active, the essential facility-like claims, that was not technically an antitrust case, basically wiped away. If you look at the EC, what you get are refusals to deal with the essential facilities doctrine. You can extend it generally to IP and interoperability, but what we do not have is a sense right now that they should be extended to big data cases. The advisor's report, recent report says no. So is it an indispensable input? No. Are we normally seeing foreclosure of effective downstream competition? No. Do we have an objective justification? At the EC level, the answer is no. At the national competition authority level, the answer is yes. And Suez being a great case, those are the kind of cases to see. So the big question is it possible to bring such a case? Yes, but the data actually has to be essential. And that's the biggest stumbling block. The reason why we've moved to regulation, people don't like case law. They just want to see results. And in fact, the world is going to change. Turns out the traditional theories of harm still work in this setting, but it has to be fact specific. But for the reasons the economic and related fields suggest, it's not likely to be in B2C unless it's something like regulated health. I'm going to stop there to keep exactly on time. Thank you.
Thanks. Thanks very much, Daniel, for this very interesting presentation. Indeed, well timed as well. Let me look around to see if there are questions. We do have a few minutes for questions if there are any. For example, on the interesting points that Daniel made in relation to the privacy concerns. I was expecting maybe some responses to that. No questions? Yes, there's a question. Is the microphone still around? Hold on. Yeah, please state your name again, just for the people online.
Do you hear me? Does it? Yeah. Okay. Hi, Tombal from Tilburg University. So I have a question about so the point that you're making that new entrants do not need to match the scale of data of the incumbent to compete. I would think that there are still some cases where they actually need to do so. I mean, if I don't know, but if you think about search engines, you know, and Google, for example, I feel like one of the reasons, I mean, you can discuss, you know, is Google better because they have more data or because they have a better algorithm? It's probably, you know, a bit of both. But, you know, because they have so much more data and so much more recent data as well, you know, if, let's say a celebrity dies, if 1 million people go instantly on Google and type that, it's going to more quickly be able to point you towards more recent news, where if it's a search engine, when there's somebody who types 10 times a day, you know, it's going to take a bit more time to get some feedback. So would you think that there are still some specific cases where you actually need as much data to be able to compete? And would there be other cases than search engines, or like maybe you disagree for search engines in the first place?
So on search engines, there's been quite a bit of work in this area. And there is some baseline amount of data that you need, but beyond that, you're not getting more with additional data. And in some cases, it's actually hurting the results if you have too much data. And it's not really about the data, it's really about what you're using it for. And I think that's really the key that we have. Now, it turns out people actually have to be on your, you know, doing the searches there. So whatever the form of search is, whether it's to look for an obituary or to look at flights or what have you, you need sufficient numbers. But part of it is also, believe it or not, it's not just the result that people care about. People also seem to care about user interfaces. So for example, you know, how is it that you're able to compete against larger companies if you have a better user interface? People value that as much. And this is one of the areas where I think Apple, not just on the hardware side, where it really does look beautiful, but on the software side has always been a pioneer by having such a beautiful user interface for the most part. And again, my sense is that if you look at Spotify versus Apple, Spotify's user interface is just better. And this is why Spotify continues in spite of all sorts of things that Apple does. And let me be clear, I've done work against Apple. So when I say something positive about Apple, you know, it really, I mean it. The reason why you're able to compete against Apple, you have to have some kind of value beyond just the organic search. And this is where product design, I think, plays a hugely important role, and one I think that has been underappreciated by the competition community. But on search, no, the empirical work suggests that with the exception of tail searches, and I think you were getting to that with like immediately with regards to the obituaries, most searches, it's not going to make a difference once you reach a particular scale. The other thing is you are probably making algorithmic changes probably 50 times a year, if not more, in a large platform. So there is no one algorithm. You're constantly tinkering with it. I'll just leave it at that.
Great, thanks.
Yes, I think I see one question by Anselm, a short one, maybe, and a short reply to stay in time. You can take mine.
Thank you very much. Very interesting presentation. Thank you. I have a question in relation to the push for ex-ante regulation. And it seems to me that the issue of trust features very, very highly. You indicated, well, the issue of privacy may be one thing where you see the consumer's concern, but it seems to me that also in other markets, there B2B markets, there is the issue of trust. You've pointed to sort of the upstream issue, what you see, for example, not just in healthcare, but also in digital agriculture, is that there are certain market players that are capable through mergers and acquisitions to vertically integrate much quicker because they already are the trusted parties of the farming community. So the Deere Corporation, Monsanto and subsidiaries, and so on and so forth. My question is this, don't you think that this then also requires a bit more of ex-ante regulation? Or in order to sort of ensure that parties know in terms of trust that they can also deal with perhaps smaller market entrants rather than rely on the trust that they already have in businesses that are long established and with which they have long partnered?
So this suggests, so what you call trust, at least in the United States, we don't necessarily see trust in the same way with, say, Monsanto or John Deere, because, for example, how the terms of which you have to give them data, and at least the consumer surveys of farmers, I mean, I guess it's not technically consumers, the producer surveys of farmers suggest they don't actually have trust. They don't realize who owns the data and why they don't own the data. They're like, it's my farm, why isn't it my data? So I'm not sure that their counterparties are necessarily the most trustworthy. One way around this, but I am sympathetic to the concern of regulation, particularly in agriculture. Some of it is going to be government regulation. In some cases, you build the trust in a very different way. So, you know, the traditional relationship may not be the one that most benefits competition, but you know, what are the ways around this? So to me, the use of blockchain contracting, totally decentralized, gets you past, in an agricultural supply chain, gets you past a lot of these kinds of traditional, I guess to use the term of art now, what is it, bottlenecks, gatekeepers, gets you past that. It's a very decentralized way. And that might create that kind of trust. Where we've seen experiments, though, has not been in the United States. I don't know about Europe, but I've seen blockchain in agriculture primarily used in the developing world. And the World Bank has been funding some of these initiatives. Is this something that could be used in more developed markets? I don't know, possibly, but I'm with you that if the concern is bottleneck in regulation, where you literally haven't seen much movement in terms of new entry in 100+ years, that suggests to me that there may be some kind of regulatory shortcoming in ways that we don't see in some of the faster moving markets. And I think it is in these traditional markets that, frankly, I'm more concerned about data restrictions, just because here the barriers seem to be much stronger. Like basically anybody can create an app, but what you're talking about, sort of the reverse of farmers and let's say equipment manufacturers, or even people who own seed, that's a harder market to break into. And so I am much more sympathetic about regulation in that context.
Thank you very much for clearing this up. I think most of the audience seems to be in disagreement, in agreement. Sorry, in agreement. That's what I wanted to say. And I read your work before, and your perspective on the privacy issue matters quite a lot from the most of the law colleagues that I talked to at the faculty. I expected more resistance, but in this room you have the audience with you and also myself. So thanks again. For reasons of time, we have to move to the next presentation. So maybe one more round of applause for. And our next speaker, Veena Saraswati. Are you still there? You can already prepare your PowerPoint by sharing the screen while I introduce you. She's an assistant professor at the Institute for Studies in Industrial Development under the Ministry of Education in India. She has a background in economics and applied economics and also worked in the field of pharmaceutical regulation before, if I'm not mistaken. Today, you're going to talk about one of the specific markets, so with some empirical evidence. Please go ahead. You have the floor, Veena.
Good afternoon, everyone. Today, I will be discussing about the digital market competition in India and some aspects. And Cloudtail was not reported as a related party, so we can imagine how much it will increase if we are reporting even Cloudtail and other top sellers. And so, so here, this point we have to read with the point made by the draft e-commerce policy on the non-discrimination of sellers. So currently we don't have a detailed information on whether they are discriminating, etc. But this much revenue is coming through their own channels. So that means that there may be possibility of discrimination also. But that we have to do more research on that. So these are the main points. I'll just conclude that multi-sided market. I have got data only for one firm, one top firm, but I'm trying to extend to other firms also. I tried for Flipkart also, but they are not reporting data under these headings. So I think like for the new age, even the annual report reporting needs to be changed. I think to account for all, to understand how much they are generating revenue from these sources, and earlier data, revenue generated from data, it was discussed earlier. So I think these things needs to be added in the annual reporting in future. And the point from our study is that study is that we need to examine the implications of the presence of multi-sided markets in pricing decisions and to see whether it is adversely affecting the offline sellers. This is the. Thank you. Thank you so much for listening.
Okay. You also have a discussant, as you know, and the discussant will be Professor Gupta, who is professor at the Indian Institute of Management in Bangalore, and his research focuses on industrial organization, regulation, and antitrust. He served as a consultant to various organizations, including the World Bank and the Indian government. So I'm sure his comments will be valuable. If you could indeed do your comments within the 7 minutes maximum, that would be much appreciated because we're short in time, but we're still looking forward very much to your
Right. Thank you very much. Thank you very much for inviting me. And Veena has given an interesting presentation. My comments will indeed be short, and I'll try and do it as quickly as I can. So I thought the basic question that Veena asked, how strong is multi-sidedness? I think that's an interesting question. So when I started thinking about it, I sort of said, okay, how does one calculate? Is there a way of actually deciding how strong is multi-sidedness? Is there an index which says this particular line of business is more multi-sided than some other line of business? So there are thoughts which occur to me. So does it mean that if there are many more sides to your business, then you're more multi-sided than, say, a business which is just merely two-sided? Is 15-sided better than two-sided? Also, does it mean that if there is more revenue, does it mean that you're more multi-sided? Then also, why not just go back to a standard definition of using market power? It doesn't matter how multi-sided you are, but if you have more market power, then, well, you're obviously stronger. Or put it in another way, if you make more, if your profits are higher, then that's what matters. It doesn't matter how multi-sided you are. I don't know if people would agree or not, but it seems in some ways, it's interesting to compare the profits, at least in India. I know IT and multi-sided firms have become very prominent, but when I look at the top businesses, people with the most revenues, etc., it's difficult to find any business, multi-sided business, which is among the top 10 or even perhaps among the top 20. Also, when you talk about multi-sidedness, why do we only restrict ourselves to the IT field, online? Because the original multi-sided businesses would have been things like newspapers or magazines, and even banks. I mean, they are also multi-sided. So it'd be interesting to compare online with offline. And also I would say that since this is in a fairly preliminary stage, so it would be interesting to compare, say, across industries, across companies, and also across countries. So if, for instance, you might say there are car hailing companies all around the world. So how well does, say, Uber in India perform versus, say, Grab in Singapore? So these are, I think, I mean, before you start off, I mean, it's usually useful to think about in what direction you want to go to. Finally, you may end up going somewhere else entirely. But nevertheless, some sort of an idea as to which way you're headed would be useful. And it would also, I think, would be interesting to formulate some hypotheses about how you think, why do you think some firms would be more, say, multi-sided than others? Or does multi-sidedness give you any benefit? Under what circumstances would multi-sidedness be of benefit? And then try to find out if those hypotheses are borne out. You may not be able to do very strong econometric work, but if you have some amount of data, cases, anecdotes, whatever, if you have hypotheses, I think sort of it makes things a little easier. I don't know how well I'm doing on time, but I've run out of comments to make. So I'll just stop here.
Thank you very much. You did exactly well in time. And I think you provided some wonderful comments from where I can see to further improve and continue the research. I'm looking around. If there's also one brief question coming here from the floor, and then at the end, I'll give you 1 minute, Bina, to briefly reflect on it, but don't answer all the questions. But take them also as suggestions. The microphone must be still somewhere lying there. Yeah, there's a question coming for you, Bina, from the audience.
Bina, thank you for your presentation. Pratiksha, UC Leuven, PhD researcher. My question was in relation to one of the title of your research. You classify your research as digital market competition in India, an empirical study into operation of online platforms. I wonder whether you looked into the Competition Commission's 2020, in January 2020 market study on e-commerce in India, key findings and observations, and I assume that you have in your wonderful paper. My question was in relation to the Competition Act and the competition bill that is coming in the amendment and what we discuss in this setting as Article 101 and 102 of the TFEU, which equates to Section 3 and Section 4 of the Competition Act of India. And where you see the current, your empirical model fitting into horizontal, vertical agreements, abuse of dominance. That is my first question of where you see your research fitting into the current legal framework and if that addresses the issues that you raise. And my second question is in relation to this empirical study that was conducted by the Competition Commission, where for the first time they highlight self-regulation by platforms, which is ex ante rather than ex post, which is what usually competition law is. And I wondered what your opinion was about self-regulation under competition law in India. Those are my two very brief questions. Thank you.
Bina, you can respond.
May I answer?
Yes.
First of all, thank you very much the discussion and also all the other comments also. And thank you, sir, for reading the entire things. And I will answer some of the things. One is regarding the index. I did not see any other studies which are doing this, and these are like very emerging areas. So I will try in future. And regarding market power, why not market power or profit alone? So I think the profit can be an indicator, that is right. But market power, I think like market power itself is based on the sale, based on the sales value of sales. So I think that sales revenue is generated through different channels. So that in itself is influenced by the multi-sided market. So that's why we are doing. And also like the issue is that they can even sell at a loss. So that is the question that's why we are studying this issue. And why not newspaper, magazine, banks, etc. That is very much true. We will try to extend to other markets in future. Then online and offline market, Uber in India, Singapore and all, that is very much good. And I will try when we do the proper analysis. And online and offline market, actually, using the current data, it is not possible to work because there is no such information. And so what we are planning is to do a primary survey and do the analysis based on that. Then hypothesis, very much true, and I will do that. Then hypothesis, I will do that. And next question on the CCI. I know about the study and we have used it earlier also. For the earlier study also, we have used it. I think the self-regulation, etc., it is very much there in policy, but what firms are actually doing is more important. And there were some issues earlier where even the commission staff were raiding some of the online platforms, etc. So that those things indicates what is the reality. And this data are also reflecting on how what is actually happening in the market. And we have seen that how concentrated is the e-commerce market also. And otherwise also we are very much, the consumers are very much familiar with this kind of system. So we can understand how it's a kind of two firms dominating the entire market. So sir's point also, e-commerce also bringing different sectors within e-commerce. Like for example, Uber and or into transport, or airline is coming, hotel booking, and these are different markets coming within the e-com market. So that kind of a data is not available currently. So only thing is that we have to depend on the annual reports or this kind of qualitative way we have to find out.
Okay. Yep, I have to stop you here, but I have to stop you here, Bena. But thanks for your answers, and please also take up the other points and complement your research with the suggestions given. Thanks again for your presentation.
Thank you so much for the call. Thank you so much, everyone, for listening. Thank you so much.
Yes. Thanks also to the discussant again for his wonderful suggestions. Now, I see we are 10 minutes behind. I don't think we can win the time back, but let's just try to stay for the last presentation and discussion within the assigned 25 minutes. So then we have reduced break of 10 minutes and no more than that. So having said that, I immediately will introduce the next speaker. And the topic is familiar to the audience because we started mentioning the DMA already, and now we have a full presentation on it. So I think the audience is definitely ready for this. And the presenter, Oles Andrićuk, I met you already a couple of times online, never in person. You're attending all of these events on competition. You're a reader in competition and internet law at the University of Strathclyde in Glasgow, Scotland. Also a director of the Strathclyde Centre for Internet Law and Policy. I give you the floor immediately.
Thank you very much. Thank you very much indeed, Niels. It was a pleasure to join in the discussion. And I'm very grateful also for assigning to me such a vibrant discutant. So I start with the obvious that I belong to this kind of overarching majority of commentators in competition policy who are supporters of the Digital Markets Act. And I would categorize myself, however, within this cluster, overarching cluster of supporters, among those who support the DMA for slightly kind of different reasons. So I am in a tiny minority of those who categorically support the DMA. And I will try to articulate my specific normative position, because based on this normative basis or on these normative narratives, my comments on the procedural development of the DMA within different decision makers or decision-making mechanism would be more clear. So I think that we have to decide at the very beginning what is the main purpose of the DMA, and obviously there are several concurrent purposes, and we can see currently that the majority of commentators move it towards the vertical protection and promotion of competition, considering the focus of the DMA on the business users and end users as its main objective, as its main normative objective, suggesting that it is the mission of the DMA to make the markets more transparent, more less arbitrarily, more fair, more accessible to business users, less discriminatory, to avoid practices which are, considered as problematic from the traditional perspective of competition law, such as self-preferencing, lack of interoperability, and the like. I, however, believe that we have to somehow unbundle the logic of DMA from the logic of sensu stricto competition law, economics, and policy, and look at the DMA as a policy instrument, as an attempt by stakeholders to shape the digital economy, the digital agenda of the European Union, and we see similar trend in other jurisdictions as well. And thus, the focus, in my view, should be not limited only to the vertical aspects, but we also have to look horizontally, i.e. the DMA as a means to facilitate new entries to the core platform services, i.e. we have to look at the DMA also as an instrument which triggers competition with what appears to be and what actually is radically entrenched set of digital markets which are listed among the core platform services. So in this and thus this is the only way for us to somehow to unlock this digital market, and this unites me, paradoxically perhaps, with those who criticize the DMA, because I also don't look at it as an entitlement of business users. For me, the DMA appears to be, the DNA of the DMA appears to be punitive in a sense. So we impose, it's like we extend the logic of Article 102, we impose additional obligations on the biggest, precisely for the reason that they are the biggest and thus most powerful. Here we go even, so we thought that we have reached the limit with essential facility, that this is an utmost normative limit of limiting the freedom of trade or freedom of contract. With the DMA, we go further than this, and we have to acknowledge this explicitly, that this is a constraint, a restriction of the best players or the most successful players in the digital markets for the reasons which motivate our objectives. But this is a punitive instrument. It's not an entitlement of business users to rely on obligations of Article 5, 6, and 7 now in the latest or in the final edition. It is an entitlement as a matter of law, because it's a legal document, of course, nobody objects this. But it's not an entitlement from the perspective of the theory. So they are given this as a bonus, essentially, for being locked within this core platform, entrenched core platform services of designated gatekeepers. I think this is a crucial normative starting point for somehow articulate and for highlighting my further comments on the substantive and procedural provisions of the regulation. And when I look at these provisions, the starting point is the goals which, as manifested in the DMA, we started with fairness and contestability for avoiding the radicalization or juxtaposition of my support of the DMA with the support of others. I would say that we can roughly categorize fairness element as a vertical aspect of the DMA and contestability element as vertical and horizontal, let's say. So because there is clear and obvious vertical dimension in contestability, but also contestability infers to horizontal dimension, which is currently almost missing because we are still shy, because we all come with this, our antitrust pedigree, where any reference to somehow policy making, proactive policy making, is being tabooized for decades, within the discourse of law and economics of Chicago flavor. And thus, if you look at this from this perspective, two other objectives which have been proposed by the parliament and which have not sustained I think that's very positive news. Contribution to enhancement of consumer welfare and fostering innovation. So if we add these two objectives, this would somehow blur the purpose of the DMA, because then we have to cross-check any action of the enforcer of the DMA, the Commission, whether this action is pro-consumer, which is kind of tricky in zero-sum markets, as many of us understand, or pro-innovation. So basically, you have to penalize a conduct and to demonstrate that this conduct is anti-innovation, which is very difficult to do because most of digital markets and most of the most successful players in most of the cases in digital markets are very innovative. The digital markets are inherently innovative. So again, this distributional or kind of allocative aspects emerges here in the discussions. It's not the innovation for its own sake, because innovation is kind of normatively neutral phenomenon. You can innovate for different good and bad purposes. So this is kind of the starting point in my comments about the latest version or the final version of the DMA is that it's good that we have abandoned this reference to consumer welfare and innovation, because this could be used by gatekeepers as essentially efficiency defense or objective justification for their conduct, saying, look, you are penalizing something which appears in one sense or another pro-innovation. So you're acting against the overarching objectives of the DMA. Second procedural point, which I wanted to highlight, if you still have a few minutes, concerns the mechanisms of commitments. And here we see that the DMA, the mechanism survived in a slightly reduced form. So now it will be only applicable to the instances of systematic non-compliance, not as proposed by the Commission originally to all instances of non-compliance. Notice, we talk about non-compliance, we're not talking about violation, which again indirectly supports my normative proposition that it's a punitive instrument, that companies are liable for not complying, not for infringing the obligations, but not complying with obligations. The vocabulary matters here. So commitments were proposed to be abolished at all. In my view, that would be another mistake. And I'm glad that the final version still has it, even if reduced form, because commitment would allow us to engage in what most of our peers economists were promoted as the main as kind of distinctive feature of this new pro-competitive interventionist regimes in digital markets, namely regulatory dialogue. because commitment, even if pro forma, you should be focused as a gatekeeper and enforcer to fine tune, to calibrate the obligations of Article 6. In reality, we understand that that would be kind of a bargaining game between the enforcer and the gatekeeper about the overall conduct of the gatekeeper, because now the obligation you would still be liable ex tunc, yeah. So that's an important juristic novella of the DMA, that your liability would not depend on whether you have reached whether you have fine-tuned the regulatory dialogue, or whether you have proposed the commitment which would somehow mitigate the negative consequences. So it would enrich the toolkit of the enforcers in terms of fine-tuning the system for different purposes, and in my view, inter alia, for the purpose of facilitating new entry at the stop level, at the stop horizontal level. Finally, which I think is very interesting observation, there was a proposition to introduce compulsory minimum fines, and again there was such a buzz about this proposal that, look, they don't comply and the gatekeepers don't comply, and we have introduced minimum fines like 2% of global annual turnover, and that was completely inconsistent with the law, with the flexibility mechanism, because you would limit. It's not the enforcement of the DMA is not about imposing fines. It's about tailoring the landscape, the digital landscape, which would ultimately facilitate either new entry or introduce more freedom and fairness and competition horizontally. But it's not about penalizing. It's a delicate instrument. It cannot be done compulsory. So it's another good news that this novella by the Parliament didn't succeed ultimately. And finally, the last point which I wanted to mention, the procedural point, is about anti-circumvention provisions. Again, we here today as well.
Olas, could you make the point in 1 minute maximum?
Yeah, I will.
Yeah. Thank you.
You are, as a gatekeeper, you are comparable to King Midas. Yeah, and Kelsen was using this metaphor that anything you touch, anything King Midas touches, turns into gold. And the same with gatekeepers. Whatever obligations you impose upon them, if these obligations are clear and precise, they will find 1,001 way to circumvent them. So we have to introduce anti-circumvention provisions. But if you look at the provisions of the Parliament, you would be really surprised to see that anti-circumvention provision was moved from Article 13 to Article 6.1 or 6a, which would mean that you would be liable for circumventing something which you are expected to comply with, which is completely, so radically interventionist that even I, categorizing myself as being radical pro-enforcement supporter, would see as like really impossible to meet this requirement. And I stop here.
Thanks very much, Olas, for giving us lots of, let's say, arguments that we can actually discuss about. It's indeed, to some extent, normative what you've given us here, and definitely interesting. So let's see what your discussant is going to respond to that. Your discussant is Julian Noah, who is Associate Professor in EU Law at Lund University, also still a lecturer in competition law at Oxford University, where he studied way back, and where he is also the managing editor of the Journal for Antitrust Enforcement. And if I understand correctly, you're also still a qualified lawyer in Germany, Julian. So we're looking forward to your comments.
Thank you. And Oles, thank you for a great presentation. I'll try to keep it brief to get us all a bit back on track in terms of time. But let's see how it goes. So thanks everyone for being here and for having me, and I apologize for not being there in person. I'm currently in Washington, DC. But it's great what COVID has brought to us, these opportunities for the online meetings. Okay, so I'll basically start off with a point that Oles made about the normative question. And for me, as a competition and internal market lawyer, I'm always a bit kind of flabbergasted by the competition lawyers who forget that this is an internal market project. This is based on the competence of regulating the internal market. So what's happening here? So what's happening here is that the European Union needs to justify its action not with regard to some kind of harm to consumers, to businesses, and so on. That's not the reason why you can impose such a regulation. You justify rules like this by different rules across member states. So if France adopts one rule and Germany adopts another, and Sweden and the Netherlands again other rules, that will make business across Europe completely problematic, in particular in the digital context. So I think that is the main background that we're talking about here. And then the question, if you look also into the case law, is that should be the main purpose that the European Commission or the European Union can pursue with regard to that specific internal market competence. But they can then load, so to speak, other aims into that kind of mix. So we have now found out that the European Union can regulate the market because there might be dangers that the digital market in the EU splinters. The question is then, how do we want to regulate the market? And so there, I think what Ole said is really helpful. It's kind of, we are talking here about how do we want to shape the market? And you introduced a very helpful point about horizontal competition, not only about vertical. But I think it's important to keep in mind that we are here not so much about let's get out of our competition law mindset and say, what do we want to have? That's the question that regulators and not regulators, that the legislators in the European Parliament and the Council and also the Commission proposing the things have to make. So what kind of, how do we want the market to look like? So we are shaping the market, and that's what the debate here is about. And with regard to that debate, I think the proposals that Ole has also discussed were interesting because it tried to essentially limit or bring back competition law instruments, competition law terms that we had that we're using so often. So trying to bring back in more competition law into this DMA with the focus on innovation and consumer welfare. Yes, sorry.
I think you can just continue. Somebody didn't
switch off the mic. Okay, yes. So there was this proposal essentially that would have brought this thing back closer again to original things that we discussed in competition law, innovation and consumer welfare and so on. And that's, I think, interesting, and Ole's rightly pointed out that that has kind of consequences with regard to legal certainty. If you bring that back in, you would suddenly have not very clear ones, or like you make the unclear ones about fairness and so on even more unclear because you bring those additional concepts also into the realm. And that brings me to my second point. So the first one was more a comment in general. The second one is much more of a question. So you briefly mentioned, and I think that's also an important question for everyone in the room, and you highlighted it as well. You mentioned the difference between infringement and compliance. Can you, and you said that the words matter here. Can you explain that a bit more? So how do you see that difference? Because I would usually think that compliance is to ensure that there will be no infringement. So those are kind of my two comments.
Yeah, thank you very much, Julian. I assume I only have 45 seconds or so, yeah?
Well, yeah, just go ahead.
Which is more than enough, yeah. Yeah, I just wanted to know the starting point before referring to the question, substantive question. I think this would probably trigger further discussions about the Article 114 as the legal ground for adopting the DMA, and I think it's really a hot issue these days. We hear some authoritative voices kind of challenging the reason or the validity even for, or the necessity of using Article 114, because there was no significant, supposedly, no significant discrepancy, or the DMA doesn't remedy this to the sufficient level, but that's obviously an open question. And when we talk about infringement and non-compliance, so basically you become liable as a gatekeeper for non-compliant with obligations. So non-compliance is preferred word to the word of infringement, which infers more categorical instance of violation of law and with some kind of moral pedigree in a sense. So when you infringe, when you are an infringer, it's tougher burden to care, moral burden to care than when you are non-compliant, even if it's a systematic non-compliant. Obviously, from legal point of view, it doesn't matter much because you violate the law in both cases, or you don't comply with the law, whatever the problem. I think it's, for me, it's quite symbolic, because it essentially means that the duties, the substantive nature of Article 5 and 6, the substantive nature of these obligations go slightly beyond of what is expected from the companies to conduct, to behave even within Article 102, which according to our long-standing tradition is the utmost encroachment, acceptable encroachment into the freedom of contract. Yeah, so refusal to or compulsory duty to deal is the most we can expect. And apparently many obligations of Article 5 go beyond this point. We legalize it with a rubber stamp, but calling that you violate the law by not complying with this provision would be, for me, a little bit symbolically less consistent or less coherent with the logic of this influence. So I'm using it mainly metaphorically, because these are synonyms, of course. But I think these synonyms, the choice within these synonyms matter to some extent. Thank you very much, Julian, for your brilliant comments.
Thank you for responding. This is also maybe the moment to remind the audience and the people at home again about the fact that some of the presenters and also discussants wrote blogs about the topics that they're presenting today. And also Olas wrote a blog. So indeed, I already highlighted the question on the goals, where indeed there's a lot to discuss. A quick comment on that, if I may, even though we're running out of time. Indeed, you mentioned the additional goals of fostering innovation and promoting consumer welfare, particularly if we see this as an internal market thing in the EU, don't match with the original goals of fairness and contestability. While I agree with that legally, of course, if we look at other jurisdictions like the US, China, where they also try to come up with similar law and do have the opportunity to take these other goals into account, I think economically speaking, it would be wise if you set up ex-ante regulation to take such matters into account, but that's how to do it remains a difficult thing. I'm quickly looking around to see if there are any pressing questions. Normally we would invite you to come with us, Discussant Julian and Olas, to have some drinks and discuss this further. I guess that we are going to do it, but without you being present. But I hope that we can all contact you in case we have questions about your work, right? Yes, good. It's getting warm here in the room, so I see there are no questions and people are eagerly looking forward to the break while we still enjoyed your presentation. So thank you all again for presenting, discussing, and for staying with us. And please also read their blogs and maybe send your comments to everyone. So now it's break time, end of session 2. We will be back in, unfortunately, already, I'm looking at the chair. Anselm, when are we going to start? Can we start 5 minutes late, or are we going to be precise?
Otherwise, people are going to
yeah.
fall over.
Yeah. So when is it going to be?
So we will resume
5:15. So run to the drinks. Thanks, everyone.
Thank you. Bye.
Ladies and gentlemen, could you please return to your seats? We're about to resume the proceedings. And it is very good to close the door at the back and keep it closed because the aircon is on. That will hopefully help you stay awake. Not that our presenters are lacking in terms of stimulating your brain, but nevertheless, we do what we can. Thank you very much. We will now continue with a session dealing with competition and IP in the digital world. My name is still Anselm Kamperman at Maastricht University and also a deputy judge in the Court of Appeal in The Hague, dealing with, in particular, patent matters. But before we get to patent matters, there is still the issue of interfaces and interoperability to contend with. Basically, interfaces and interoperability after Google versus Oracle. And in order to introduce the topic by means of the keynote speech, we have with us via Zoom Professor Pamela Samuelson, who is based at the University of California at Berkeley, where she has appointments both in the School of Information Law and Bothwell School of Law. Now, I see that you are online and on the screen. Welcome. Thank you very much for joining us this afternoon. And as soon as you are ready, you have the floor.
Well, great. Thank you for the invitation to participate in this event. I'm always glad to talk to my colleagues in Europe about intellectual property and competition law. So I'm sorry I'm not there with you in person, but I hope that the talk will enrich your understanding of at least the way the United States might look at some of the issues that all of you look at as a matter of EU software directive. So here we go. So interfaces and interoperability after Google versus Oracle. I like to start with an overview slide. So one of the things that you will, many of you, if not all, will know that the software directive in the EU regards interfaces as ideas or principles that copyright law doesn't protect. Now, Europe actually got a good handle on the interface and interoperability issue back in 1991, and the United States took a little longer to get there. There was a debate about this topic, the copyrightability, so to speak, of application program interfaces starting in the 1980s. But by the early 1990s, the courts had reached general consensus that application program interfaces that were needed for interoperability were not protectable by copyright law under various doctrines, sometimes fair use, sometimes merger, sometimes what we call saint affaire, or kind of standard things for works of that kind. And then the Federal Circuit in the 2014 decision in Oracle v. Google decided that the copyrights could protect interfaces because they were minimally creative, and the court also decided that Google had not made fair use of the Java API, that parts that it used, and the Supreme Court eventually heard both the appeal, Google's appeal on the copyrightability as well as the fair use issue, and ruled in Google's favor. And so we have now, I think, a kind of consensus across the pond that interfaces should be protected by copyright law, although we use different doctrinal understandings to reach those results. So again, back to the 1980s and 1990s on this issue, the European Commission first had an experience with compatibility when a number of the makers of compatible devices that could work with the IBM computers, IBM would change the interfaces so that these products that were supposed to interoperate with the IBM system wouldn't do that. And the commission decided that that was an abuse of dominant position, and eventually IBM decided to give up on the kind of control over interfaces that it wanted to have, and opened the market. But it taught the commission a lesson about the importance of compatibility. So when the question came up in the early 1990s about should copyright protection be used to protect computer programs, the commission was in support of the idea that that copyright should protect computer programs, and thought of them, as in the US, as literary works because they're writings of authors. But they put in a special rule that interfaces that enable interoperability are not within the scope of protection that copyright law provides. And moreover, the directive decided that it was lawful to reverse engineer computer program in executable form to get access to interface information if that was really needed to do that. So by 1991, the European Union, I think, adopted what was a really sensible rule about interfaces and interoperability. In the US, it took us a lot longer to kind of reach that result, but I think it's important to sort of understand that dominant firms, especially IBM in the 1960s through the 1980s, wanted to exercise control over interfaces for a couple of reasons. One is that they wanted to control who could write programs that would actually run on their machines. And second, they didn't want other companies to develop platforms that essentially would allow the programs that had been developed for the IBM system to run on the alternative platform. And there was a big litigation and then an arbitration between IBM and Fujitsu, because Fujitsu developed software that emulated the IBM's 360 computers and allowed people to use the programs that they had or that they could acquire that would run on the IBM system to run on Fujitsu system as well. So IBM was a long time strong supporter of strong copyright protection for interfaces. There were two decisions back in the 1980s that decided that structure, sequence, and organization of programs could be protected, and also that interfaces, you may want to get compatibility with another program, but that's an objective that doesn't have anything to do with copyrightability. So the argument for protecting interfaces by copyright kind of grew out of these two cases. But then in 1992, the Second Circuit Court of Appeals decided a case called Computer Associates v. Altai. And the court decided that Altai didn't infringe because of similarities between the scheduling programs that Computer Associates had developed and that Altai developed were largely due to the need to be compatible with the IBM operating system programs. And the court talked about these as external factors that constrained the design choices that Altai had. And several other courts soon thereafter also adopted similar rulings, albeit with sometimes different rationales. So sometimes they relied on the Sena-Fair doctrine, sometimes they relied on the merger doctrine, sometimes they relied on fair use, but they reached the same result. Then came the Oracle v. Google case. It didn't start out as a litigation. Sun Microsystem had developed the Java API and had supported for a long time that copyright should not protect program-to-program interfaces. And Sun and Google negotiated about the possibility of Google taking a license to use the Java technologies for the Android platform, but they did not reach an agreement on that. So Google ended up using parts of the Java API anyway, Oracle then acquired Sun Assets in 2010 and sued Google for patent and copyright infringement. The patent claims basically fell out of the case, but because there were patent claims in the complaint, the appeal didn't go to the Ninth Circuit as it usually would, but rather to this Court of Appeals for the Federal Circuit that usually hears patent claims, but not really copyright. The Court of Appeals reversed a trial court ruling that the parts of the Java API that Google re-implemented in Android, the trial court said not protectable. The Court of Appeals said it was protectable. And so the case went back for a jury trial, and the jury trial was about the fair use issue. Now, fair use is not a concept that most of you are very familiar with, but let me do you a real quick introduction to it. So the exclusive rights of copyright are subject to fair use. Fair uses are not infringements. There are certain favored uses, and there are 4 factors: the defendant's purpose in making the challenged use, the nature of the copyrighted work, the amount, the substantiality of the taking by the defendant, and what harm, if any, there has been to the market. And there are many, many cases involving fair use, but this was the first one to involve really interfaces as fair uses. So the jury found in favor of Google's fair use defense, but on appeal, the Federal Circuit said, no reasonable jury could have found fair use, and decided that the purpose in copying was overwhelmingly commercial, which usually tips against fair use. And also it was non-transformative. It was used for the same purpose as the Java API declarations had been used previously. And so it didn't do something like a parody, which transforms the original to make something new that's kind of a critical commentary. The nature of the copyrighted work, well, the court said, yeah, the jury could say that there are some functional considerations there, so that factor favored Google, but the amount taken was substantial, 11,500 lines of what the court called the declaring code, and the court thought that the evidence of harm to Oracle's market was overwhelming, and so rejected the jury defense, and then the Supreme Court decided to hear both the copyrightability and the fair use rulings. Now, the big takeaways from the Supreme Court's decision in Google versus Oracle are these. The court gave very significant weight to the investments that 6 million Java programmers had made in learning the Java API declarations so that they could write application programs that essentially would run on the Android platform without having to learn a whole new dialect of Java. And those declarations were not so much valuable because of the creativity that Sun and Oracle had contributed, but rather because of the investments that these programmers had been making in learning how to use the declarations to write applications. And the court basically said the re-implementation of an interface allows creative new computer code to easily enter the market. And the Supreme Court perceived Oracle as asserting copyright in a manner that was basically anti-competitive, that would interfere with rather than further copyright's basic creativity objectives, and decided that actually this was transformative too. Now, usually the nature of the copyrighted work factor doesn't count one way or the other. But in this case, the court thought it was so important that it discussed that factor first, and it characterized the Java API declaring code as a user interface. That is to say, here's a programmer that uses a method call because it wants to connect this particular function that they want to be performed with implementing code over here. And the Java API declarations essentially was a link that, that bound the method call to the implementing code. And Oracle wasn't claiming copyright in the method calls, and they were claiming copyright in implementing code, but Google didn't copy that. The only thing that Google used was that interface between the method call and the implementing code. And the court said that reusing those declarations allowed the programmers to use their skills in a new computing environment, and their re-implementation of the declarations was itself creative, but it also fostered lots of creativity by Java programmers. In the United States, a transformative use is generally speaking a pretty cool thing when you're in fair use understanding. And that usually means that you add something new with a different message or purpose. Here, the court basically kind of expanded the concept of transformativeness a little bit more by saying that Google had this transformative purpose in using it because it enabled so much additional creativity. And Android itself was highly creative and innovative, and it made it easier for more people to write more programs. The court also emphasized that re-implementing interfaces in the computer software field is a common practice. And even Sun didn't try to make money so much on the interfaces, but was really trying to compete on applications. Now, 11,500 lines of code, this kind of sounds like a lot, but as the court pointed out, this was actually only 0.4% of the Java API code as a whole, and it was also a very small amount of the 15 million lines of Android source code. And more importantly, the court decided that Google only used the declarations that it needed for the smartphone platform. The Java API was originally developed for laptops and desktop computers, and they have a lot of functions that they have to do, like having mouse functionality that you don't do with a smartphone. And smartphones need a lot of additional things like GPS technology that you don't so much have with the desktops and laptops. So the court basically said, look, they only copied what was really necessary in order to have a computing device that could do the common functions that all computing devices have to do. And the declarations were the key to unlocking programmer creativity. Was there any harm to the market? Well, the Supreme Court was completely unconvinced by that. And part of it was because the jury had heard lots of evidence. Oracle said, oh, overwhelming evidence of harm. And Google said, really, you couldn't enter the smartphone market. And the license that Sun might have wanted to give for use of the whole Java technologies is a different type of license than just for the parts of the Java API that we used. Sun failed, Oracle failed, so there wasn't any harm to the market. And the court actually in this part of the analysis talked about how enforcing copyright could harm the public. It could be anti-competitive, and that shouldn't be allowed as a matter of copyright law. And so that factor too supported the court's fair use analysis. Now, the court did not speak so much about compatibility. It hardly spoke about it at all. And many of the other cases that have been involved have ruled on interface protection were truer compatibility cases because Altai's program, for example, was trying to interoperate with the IBM programs and do as successfully as possible, whereas some of the programs written for Java platforms don't run on the Android platforms, and some of the apps that were developed for the Android platform don't run on the Java platforms. So it's not whole compatibility, but the court basically did not find that to be a negative factor. So Mark Lemley and I have written a paper called Interfaces and Interoperability after Google versus Oracle. It was published in the Texas Law Review in December. And we make the argument that all of the decisions that we point to, there are 6 of them in all, that say that APIs are unprotectable by copyright law, are still good law, and that fair use should not be the only defense that programmers who want to re-implement interfaces should be able to do. And the truth is that compatibility promotes competition, ongoing innovation, and the public's access to really great technologies. And so the Supreme Court essentially recognized that in its Google decision. And so here we are now in 2021 and thereafter, where re-implementing program interfaces in independently written code is fair use as a matter of law in the United States, maybe under other doctrines than just fair use, but we're going to see a lot more fair use defenses in software copyright cases now, I think, and not just in cases involving APIs. I think one of the things that's actually very notable is that that not just IBM and Microsoft, but many small and medium-sized software developers, open source developers, industry associations, and computer scientists supported Google's fair use and copyrightability defenses. And many of them were lucky that Google and Oracle, which are big companies, could fight this out for more than a decade. So now that they benefit, the smaller companies, the startups, the medium-sized companies will benefit by the existence of a rule that has been prevailing in the EU since 1991. And I point here to the CJEU's SAS Institute versus World Programming Limited decision, which I think reached similar results under the software directive. So that's a quick overview of interfaces and interoperability. I think it's very relevant to the competition policy and to the intellectual property policy issues that you are debating here in Brussels. And so thank you again for your attention, and happy to answer questions as appropriate.
Thank you very much, Professor Samuelson. This really gives us some food for thought. Are there any questions already from the audience? Because otherwise I have one, but yes, all the way at the back. Do you have a microphone there?
Okay, can you hear me?
Yes.
Okay, thank you for your presentation, Professor. And I'd like to ask you if you can delve a little bit more on the potential impact of this ruling on big tech, and basically how large players in the digital economy owning huge platforms might be less able to protect their walled garden by means of this ruling. I mean, this might allow small startups to make use of so-called adversarial interoperability, if I'm not wrong. Do you believe so as well, or you think that this might not be a real issue for them?
Yeah, so there is a question in the United States that's different than the question that would happen in the EU about whether if there is a license restriction on reverse engineering, for example, to get access to interface information. In the EU is under Article 6 of the Software Directive, such efforts to kind of like stop adversarial interoperability cannot be enforced in the United States. It's a more equivocal thing. But I think the Supreme Court's decision in the Google versus Oracle case strongly supports allowing adversarial interoperability. And again, many of the briefs that were filed, there were, I think, 70 briefs, amicus curiae, friend of the court briefs filed in support of Google and some in support of Oracle, but the ones on the kind of in support of Google were very strongly supportive of adversarial interoperability. So I think that, you know, it's not from the standpoint of at least some of the people I've talked to in the software industry, the Supreme Court's decision isn't quite as good as the no copyright for interfaces, period, because fair use is often said to be, you know, case by case and so forth. But the Supreme Court decided that on all four factors, that Google's use of the API was fair use as a matter of law. And so even though, you know, they relied a little bit on the jury, they made fair use into mostly a legal matter for the judges to decide. And there's lots of language in the opinion, including citations to about half dozen of the cases that have held that interfaces are not protectable by copyright law at all, as a matter of US copyright law. So I think that they bolster some of the cases. And again, Mark Lemley and I explained that. And also, I think to pick up on your point, walled gardens are sometimes kept walled by interfaces that people don't want to share. And we explained that that having a ruling that so strongly supports the reuse of interfaces may be helpful in overcoming the walled garden problem, as well as just software to software interoperability.
Thank you very much. Related question to this issue is sort of the regulatory push that is visible in the European Software Directive for interface information to be made available upon the penalty of perhaps allowing reverse engineering, as the Software Directive would then permit. That has really created for a push to openness. And this is also then perhaps visible in the subsequent decisions at competition law level in relation to the Microsoft cases.
Yes.
Do you see a similar development in the US based on the case law? Or would you say that indeed, as the fair use defense is rather a bit more piecemeal, that the industry practice has perhaps not developed to the same extent as there is development in Europe? And that then also goes to sort of the industry makeup. The US being home to some of the largest software development companies, whereas the European Union has taken a distinctly different route with more open source type of development in this way, SAP being more or less the only big European software developer.
I think it was actually really significant that both IBM Corporation and Microsoft, as well as dozens of other companies of various sizes, have decided that actually interoperability is a good thing. And they supported the unprotectability of interfaces before the Supreme Court. In fact, one of the things that I think is worth pointing out is that of the 27 briefs that were filed in support of Google, that all but 3 of them wanted the Supreme Court to say no copyright on interfaces, period. Now, the court, again, ducked that question. Mark Lemley and I explained that there's more in the Supreme Court's decision that supports those cases than supports the Federal Circuit's view that interfaces are protectable by copyright law. But I don't know that we're quite there yet in terms of sort of demanding disclosure of interfaces. So I know that that's part of the new Digital Market Act, and we'll see how that plays out. I do think that the Biden administration is much more pro-compatibility and pro-interoperability than previous administrations. So I think they're hospitable to the idea, but we're not quite there yet. On the other hand, again, the strong support from the industry. So Apple is really the big actor now. That's a dominant firm that doesn't want to disclose interfaces. But IBM, which used to be the highest of highest protectionists when it came to interfaces, now is like saying, oh no, interfaces should not be protected by copyright law. So that's a big about face for them.
They have lost market power and changed their business
Yes.
environment accordingly.
Indeed.
Okay, thank you very much. If there are no further questions from the audience, we move on to our next speaker, and hopefully, Professor Samuelson, you will remain online and also chip in, because the next topic is also of interest. This concerns the antitrust response issues in relation to IP and data. And in order to discuss this issue, we have Mr. Miles Rogerson of the World Intellectual Property Organization. And
do you have a presentation which needs to be shared?
Yes. Okay, good.
Yes.
Thank you. Is it the red button? No, that's the laser.
Can you tell me which one of the presentation?
Conference presentation. Thank you. Cheers. Thank you.
Good evening, everyone. The views I express tonight and in my paper do not necessarily reflect the views of my employer. Given the limited time I have, I thought I would restrict my presentation to the earlier section of my paper, which deals with competition issues arising out of differences in access to data between competing firms. Before I do that, I'd like to make a brief comment about intellectual property rights. Part of the economic rationale for the existence of intellectual property rights is that they exist as both an incentive and a reward for innovation. In return for temporary exclusive rights over their creation, IPR holders are granted, they share the fruits of their labor with society. And it was this incentive to innovate, this bargain that my paper focused on when it came to addressing the impact of competition interventions on IPR holders. You may have come across the notion that data is everywhere. This narrative depicts digital markets as being awash in data as it is produced in such great quantities and at little or no cost. As a result, differences in access to data cannot be the source of competition issues, as what one firm creates, another should be able to replicate with ease. And as a result as well, therefore, incumbents are supposedly eternally vulnerable to innovative market entrants. In practice, this is not necessarily the case. The costs of developing a platform and marketing it to attract users from which you can gather data is already quite a significant barrier to entry. This difficulty is compounded by the presence of network effects. The value of a platform for one group is dependent upon the presence of another group on that same platform. By way of example, what makes Facebook so valuable to its users are the large number of other users on that same platform. While they may be tempted by the features of a market entrant, the fewer number of users on that market entrant will dissuade them from switching. Additionally, certain online undertakings rely upon user data to refine their service. For instance, search engines use algorithms to provide relevant results for their users. These algorithms can be continuously refined by being fed user data. As a result,
large incumbents are at a competitive advantage due to their access to the data of their large existing user base. In both these examples, what you can see is a snowballing effect, where existing access to data aids market incumbents to attract and retain users. At the same time, users are faced with significant switching costs in the event that they choose to migrate to a market entrant. Imagine if you wanted to change your email address. Now think of all the web account details associated with that email address, which you would need to change as well. In summary, a greater access to data can help market incumbents to create and/or cement a position of market dominance. Of course, a position of market dominance is not illegal. It is only when that position of market dominance is abused that it becomes a concern for competition authorities. Now, given the competitive significance of data that we've just discussed above, then impeding a rival's access to data could be such a form of abuse. And one example of this could have been Google's privacy sandbox plan, which I believe they announced in 2021, which the United Kingdom Competition and Markets Authority took issue with. So Google announced its intention to replace the use of third-party cookies on Google Chrome with a tool of its own that would offer greater protection of user privacy. Some welcome this, as cookies are often criticized for being overly invasive in the way that they track users across the web. However, cookies also help advertisers target relevant consumers, which in turn can help to support free online content. The CMA was concerned that if Google was able to substitute cookies with a tool of its own, then it would be able to continue to benefit from the data it harvested from users whilst preventing others from access to the same. In response to these concerns, Google proposed a number of commitments which the CMA accepted. Now, while this case was resolved before any harm can take place, it still highlights the potential harm that can come from a rival being deprived of the access to the data that they need to compete effectively. In the event that future such cases are not resolved so amicably, what can we do to ensure access to this essential competitive input? Well, one option is to look at applying the essential facilities doctrine. I've written here the definition of it. I think you're all familiar with it. This was, as we know, originally applied to physical infrastructure. It was later applied to intellectual property. And in the case of IMS Health, it was applied to data. Likewise, I believe you're all likely familiar with the facts of IMS Health, so I will go ahead and skip that as well. In its defense to the Commission's interim decision, IMS argued that the compulsory licensing of its database rendered copyright protection meaningless. Firstly, it compromises the right of the IPR holder to choose with whom they do business. More crucially, it risks disturbing the incentive to innovate that yielded that essential facility in the first place. When it comes to data, or more specifically databases, such a compulsory license may reduce the incentive for rivals to produce their own databases or to create their own means of harvesting data. Additionally, given the central importance of innovation as a driver of competition in these markets, how suitable is this remedy with its potentially innovation dampening consequences to the question at hand? That said, given what we've discussed, is innovation truly the prime decisive factor when it comes to competitors in these markets? Given the presence of network effects, high barriers to entry, and switching costs, are market incumbents not just enjoying some form of first mover advantage? Additionally, when it comes to the case of IMS, when it made it to the Court of Justice of the European Union, they clarified the conditions under which the refusal to grant a license of an IPR constituted an abuse of a dominant position. And one condition was that that refusal had to prevent the emergence of a new product for which there was potential consumer demand. When this interpretation of the essential facilities doctrine is applied, can it really be argued that innovation will be dissuaded? Well, much depends upon how you interpret new. But in any case, there is an argument that in the presence of the competition issues that we've encountered, the requirement to introduce a new product should be removed. The logic being that in the presence of the competition issues we've observed, there is a sort of absence of effective competition. By restoring that effective competition, by however means necessary, you restore the imperative to innovate to incumbents. What these conflicting views highlight is a potential trade-off between what Inga Graef in her 2019 paper described as competition in the market versus competition for the market. What do we mean by this? Well, competition in the market is, by way of an example, taxi firms. They compete on quality and price. Uber competed for the market by introducing an innovative new business structure. By intervening in markets, do we dampen the incentive to compete for the market? Conversely, by failing to protect the effective competition that we've come to love, do we lose with it the dynamism and the innovations that we've come to value as well? This tension seems to echo the historic friction between IPRs and antitrust law. In past, IPRs were viewed as anti-competitive due to the exclusivity they afforded their owners. Thankfully, there is now a growing consensus that IPRs contribute positively to dynamic competition. However, our discussion has touched upon the necessity to intervene in markets and at times to interfere with the operation of IPRs. When this will be appropriate to do so will need to be addressed on a case-by-case basis. But to arrive at a conclusion, competition authorities will need to consider the importance and the availability of data in the market in question. What my paper hasn't addressed, and is perhaps my next topic of investigation, is the suitability of existing antitrust remedies and theories of harm for tackling competition issues in digital markets. They are, of course, they are incredibly technical and so require a thorough investigation. However, they are also incredibly fast-moving and so perhaps require a responsive decision-making process. Additionally, just personally, I am quite curious about the potential for the right to data portability to help to reduce entry costs or switching costs rather for market entrants. Thank you very much. Thank you very much, Mr. Rogerson, for that very concise overview with a lot of topics already touched upon. But the topics will be touched upon by Professor Peter Georg Picht, who is Professor of Commercial Law at the University of Zurich, but also director of a department at the Max Planck Institute for Innovation and Competition.
Thank you. Thank you for inviting me. It's a pleasure to be here. I don't know whether my mic is actually working. Seems to be working. Excellent. So yeah, first of all, apologies for being a bit late, but I made the mistake of confusing Tervurenlaan with Avenue Tervuren. So the Uber dropped me off in the middle of nowhere and then I had to take a tram to get back and stuff. So apologies, but I made it halfway on time. And I didn't need to use the time in the tram to read your paper because I found it a very interesting read before that. And you certainly, the paper has such a breadth of insight and topical features that it really gives an excellent overview, not only on key topics in the field, but also on really the key cases, I think, that are in there. So I really enjoyed it. This being said, allow me a few kind of questions, maybe a dialogue, rather than just, uttering my points of view. So one point I found interesting is that starting from the finding that we probably have too little access to data in some areas, which is, I think, well-founded and there's certain consensus on that. You go on to focus quite strongly on the essential facilities doctrine as a competition law remedy to that. Now, certainly, the why the essential facilities doctrine would be topical for that is evident, right? Especially since, as you correctly pointed out, since its development into the area of IPRs, Microsoft, McGill, ISM Health, and such cases. At the same time, there are voices, at least in Europe, that have strongly questioned the aptitude of essential facilities doctrine to address data access questions. And you certainly, you know, for example, the Crémer-Montjoie opinion that was kind of a founding paper for the DMA, but also other Kerber, Schweitzer, the legal opinion that prepared kind of the most recent overhaul of German competition law. So they all found that essential facilities doctrine is kind of pointing in the right direction, but has in its current shape as an operational legal doctrine some shortcomings that make it difficult to tackle data access by using that doctrine. For example, essential facility basically requires existing markets. So there needs to be a market, a downstream market controlled by the upstream essential facility. And sometimes when you require access to data, you may even be able to identify one particular market that it is at stake, but interesting data portfolios have kind of the characteristic of being potentially interesting to a range of markets, and some of these markets at least may not have you know, gone off the ground as yet. And also there was the fear that showing that a particular data portfolio qualifies as an essential facility, meaning that the duplication of that portfolio is not reasonably possible, might be too high a threshold and such things, and a couple of more points, you know. So I would find, as my first question, I would find it interesting why you kind of counter this opinional trend by relying mainly on the essential facilities doctrine.
Well, the reason I went for the essential facilities doctrine to start with is just it's where my investigation led me. That's just the product of the research that I was doing. I'm not as familiar with the case law you mentioned, but I do agree with the sentiment that the essential facilities doctrine is perhaps not the most appropriate tool to use in this circumstance. It was merely the sort of clearest, a bit clunky, I admit, example that I could bring up to look at the connection between the antitrust intervention and then the knock-on effect onto innovation. One particular point that I don't know if you brought up that I would think is inappropriate about the use of the essential facilities doctrine is it seems to, well, I mean, at least in the case of IMS, it was looking at a database, not necessarily a data flow. And the competition issues that I've been addressing, they have more to do with, you know, a gatekeeper's ability to access data as it constantly flows to them, rather than sort of a set database that exists. And so I take your point that the essential facilities isn't the most important remedy that could be examined in this context, but is just the one that I was led to.
Well, I mean, I see that. At the same time, you could make a point maybe in a subsequent version of your paper that we might want to think more closely about adapting the essential facilities doctrine or some, you know, new similar doctrine to data access concepts. Because, I mean, as you know, so reading this about the essential facilities doctrine, what the EU Commission did is say, okay, let's throw away the essential facilities doctrine. So apparently the entire, you know, traditional competition law doesn't work that well. So let's come up with some nice pieces of regulation. And we do now have data access regulation, both the DMA and also severely in the Data Act, actually. So in my perception, you could at least, you know, tell the story that maybe shortcomings of the essential facilities doctrine having pointed out, this was also a good point for the Commission to rest its wish for regulation on, right? So and maybe since the regulation is likely to capture some important data access constellations or settings, while others may still have to be caught by general competition law, I think that it is worthwhile to still think about whether we should adapt the essential facilities doctrine. So this was maybe one point, you know, that came to my mind. Another point that is always like the white elephant when we talk about data and access and balancing of incentives and so on. I think that you are completely right to underline the necessity to balance disadvantages from data access and advantages from data access with a view to dynamic efficiency. And you're also completely right to say that IP rights tend to add an additional and quite complex layer to that balancing exercise. Which begs the question, does access to data as such already involve IP rights? Which, brings me to asking you whether you think that data is or is embodying or is protected by or should be protected by intellectual property rights, maybe rights of a form, of a type that we are not seeing at present. I know that IMS Health was a data access case and that it has an IP rights dimension, but that comes, of course, from the copyright protection to that data structure. And Microsoft, the more tricky case, there was not certain whether there were actually IP rights, but at least there was so much probably trade secret, so protected trade secrets in the game, and probably some copyrights that you had a genuine IP rights dimension. But there may be data portfolios without clear IP rights protection. Does the IP rights dimension still, figure into the balancing exercise then?
Well, a lot of questions there. To answer quickly the notion of existing protections of IP, of data rather, as you say, we have already the copyright protection. We also have the sui generis right. I don't think that more IP rights in data are necessarily needed. In fact, I think they would be counterintuitive into this point. Part of the rationale for the existence of IP rights is to make the intangible and the non-rivalrous limited and commodifiable. And with the problem being that there is a limited access to data, putting up more legal walls between accessing that data, I don't think would address many of these problems. Sorry, your second point was?
No, that's fine. So you think we shouldn't generate more IP rights to data? And basically, sorry, I need to use the microphone. I think we can cut it short there, because I take from what you say and also from the paper that it really depends on whether there are IP rights to the data portfolio. It depends on the finding of IP rights covering all or part of the data portfolio, whether we actually have to take this additional IP rights dimension into account for the balancing exercise. One could maybe question that position. So I don't know how much time we should be spending on this discussion.
It's fine for now.
It's fine for now. Okay, yeah, so you just the interesting thing is that we have been discussing data ownership for quite a while, whether it should be classical ownership to data, and the consensus is probably not, unless you have copyrights or some other more traditional types of IP rights. This may be so, but it doesn't take away the tendency to protect control over data somehow, right? So what we are seeing from not granting IP rights protection to data is that this gives a push towards factual control. The search for factual control over data portfolios and a big reticence to actually share them. Unless this sharing is framed by relatively restrictive contracts, right? So there's a contractual protection element to it. So this, to me, shows that there are similar considerations on the part of the data holders as you frequently find on the part of IP rights holders, right? And there may also be similar innovation, issues in the game, even though you cannot, fix a label to the data portfolio and say, this is copyright or this is data ownership, but the considerations may be similar.
I think there's also a raised hand from Mr. Samuelson. Do you want to contribute to the discussion?
So I just wanted to chime in that that in the U.S. a lot of the same concerns about data monopolies are popping up, and there are a couple of different tools that are being used to try to do that. So one is that the National Academy of Sciences was completely opposed to an equivalent to the sui generis right that the EU developed. Also, US government agencies have open data requirements when you get money to do research from the federal government now. The data must be open. Many foundations actually do something similar, and even publishers now are requiring open data. So there's a real push to that. My own experience with the Google Book settlement was there was a lot of concern about the competition policy consequences of Google having access to all the information from the 30 million books that they had scanned that its competitors didn't have access to. And the Department of Justice actually took that pretty seriously. So while that wasn't the reason the book settlement was not approved, it was a consideration. And I'd be happy to send you some information about some of the other people who are writing about data monopolies. So so get in touch, okay?
Thank you very much for that contribution. Now, let me try to turn the matter on its head, because quite often there is data sharing, even between competitors. But then perhaps the abusive conduct lies elsewhere. And this is perhaps even a bridge to the next topic. It's sort of use of software, algorithms, and data streams in order to then collude without really colluding. We have this nice Parnell question where the prices of spare parts of automobiles were raised simply because of the information exchange between car manufacturers, but it's just a data stream. And they were simply saying, well, we use the same software suite. We are not colluding, we are just sharing information. And of course, the suite is proprietary, that's simply proprietary software, to which all these car manufacturers simply happen to have taken a license. So I'm not quite sure whether, from purely a competition perspective, it's just about access to data and openness. You see also the reverse is possible there. Because of openness in terms of data sharing, other types of collusions. Also there, seems that competition authorities are still sort of struggling with these types of concepts as well. So with that, I would like to bridge to the next topic, which concerns algorithms and the topic of AI-generated inventions, whether there are any implications for patents, where immediately we can ask ourselves whether there is any difference, if any, between AI-generated inventions and computer-implemented inventions. But in order to address the topic, we have the next speaker, whose presentation is now being prepared. So, Gaëtan de Rassenfoss. Yes, well, as a Belgian, you are sort of happy, I guess, to be home, because normally you are based at the École Polytechnique Fédérale de Lausanne, where you are in charge of the innovation and IP policy there, and also have appointed in College of Management and Technology. Do you have the clicker? Thank you. Perfect. Do you have the working mic? Then take it. You have the floor.
Yeah, I'll take this one. Okay. All right. I will actually stand up because it's getting late. Everyone is tired. I see eyes closing, so and so am I. So let's work with it. So it's going to be a nightmare for the camera, but I guess it's no big deal. All right. So indeed, in the next Yes, in the next 12 minutes, we'll go over, we'll actually question ourselves of how should we treat AI-generated inventions in terms of patent protection. So there is a debate in the legal literature. I'm an economist. In the law literature, should we should we actually allow patent protection on AI-generated invention? And the debate has been evolving around, should we actually allow machines to be listed as inventor, more or less, right? And so that's where the debate is going. Now we take a different perspective in that paper, which is actually, I forgot to mention, John worked with Adam Jaffe from Brandeis University and Melissa Wasserman from University of Texas Law School. And we ask, regardless of what the law says, from a normative perspective, using economic argument, should we actually allow or not the patentability of AI-generated inventions? And when I say AI-generated inventions, to be clear, I really mean inventions fully automatically innovated, created, right? So there is no, think of it as there is no human input, right? And we had Miles, who actually nicely explained that the patent system is both a reward and incentives. Here, if the inventions are just created automatically, why should we actually need to innovate, to incentivize, right? And so that's the core, the starting point of the interrogation. And so to consider, to guide us through the thinking, let's consider the following thought experiment. So we'll introduce an invention machine. Let's call it an invention machine. And that invention machine creates invention at zero cost. They come for free, right? They cannot, so the invention developers cannot commercialize the invention themselves. So we have inventors and developers or implementers. Okay, the machine will not be able to implement, surely. And finally, inventions are in the public domain. That's what we assume for now, right? Inventions are free to use. And we can think of this as, indeed, an AI software generating inventions automatically. And by the way, this is not science fiction. It's actually already happening, right? So we do have inventions that are being produced autonomously. And so we ask, is society better off if we allow patent protection on these inventions or not? So let's go back in time and let's call the invention machine a university, right? So indeed, we have the create invention at zero cost, zero private cost, at least. Inventions just appear thanks to public funding. Universities cannot commercialize these inventions themselves. And in addition to that, inventions are in the public domain, or used to be in the public domain a couple of decades ago. I will get back to that, it's important. Especially before the 1980s here, we focus on the US, we had the Bayh-Dole Act. Before the Bayh-Dole Act in the 1980s, universities and PROs, public research organizations funded by federal money, could only license inventions non-exclusively, right? So there were no exclusive license being granted on inventions arising from federal funding. So they were indeed available for everyone to use potentially. So before the Bayh-Dole Act, only 5% of university inventions, patented university inventions, were actually licensed. And that's what we call in economics the free good problem. Essentially, no one wants to work with a free good. No one wants to sell a free good. And a free good is a good that is available plentifully for everyone's enjoyment. And let's think here of air. Who will actually sell air, right? There is no way you can sell air. It's available for free. So that's the core of the problem. If you give the inventions for free, somehow no one would want to invest and commit resource because other potential new entrants will come in, which will reduce the profits. There is actually a way of selling air. It's by creating scarcity. And there is here an example of a Swiss startup, Swiss Breeze, that sell the best, most pristine and freshest Swiss can air, gather it in the most beautiful and remote lake and mountains regions, right? So they have created scarcity by canning the air and indeed selling it in polluted cities in China and India, right? Where air is no longer a scarce resource. And so essentially, the Bayh-Dole Act, by allowing universities to license exclusively in the inventions, created scarcity on that free good that were inventions. So essentially, without patent protection, there would be few technology implementers. So few companies would want to come in and commercialize the invention, invest, follow on R&D marketing activities to bring AI-generated inventions to the market. And so that's already suggests, that's one reason for why indeed we should have some form of IP rights for that scarcity reason. So here we are moving away from the reward and the incentive effect. It's really more like a market commercialization effect of IP rights, which then becomes very important, even if the invention has been generated for free. But then, you can say, well, there is not only patents, firms can actually keep these inventions secret and transfer them, and secrecy actually creates scarcity. Sure, that's a good point. However, there are a couple of issues with secrecy. So secrecy is definitely one option, but cannot be the default or the only mode in that case, right? And so we know it's not always an effective protection mechanism. We can reverse engineer. It hampers or limits transaction in the markets for technology. So we want, a clear right that we can easily trade, and patent here has been shown to actually act as a way of transferring technologies across entities. And it also limits learning opportunities from the patent literature, so that the disclosure effect of patent. So secrecy might work, but might not work in all cases. So we need something more. Okay, I've introduced a couple of assumptions, so let's relax them and see what happens when we consider, less extreme scenarios. So we start by saying that invention machine creates inventions at zero cost. That's not exactly true, right? It might be true in terms of the invention machine creating inventions, but creating the invention machine in itself is presumably costly, right? So even if you produce inventions for free, you need to come up with the AI algorithms. You need to get access to the data, and that is costly. And so here, without protection, the output of invention machines would be difficult to transfer, which would reduce the incentive then for firm to invest in the creation of such machine in the first place. It's kind of like backward inducing argument. And at the limit, if AI inventive firms are unable to transfer the technologies in the market in the first place, well, they will not invest in the creation of these AI machines, right? So there is no financial incentive in producing these invention machines. Therefore, we will not have invention machines in a sense. So that's another reason for why we need some form of patent protection or some form of IP protection, is to incentivize the creation of such machines in the first place. Of course, then the question becomes, how much protection should we offer, right? Should it be a traditional patent right with the same right? Should it be a different type of rights with maybe more limited scope, time, or coming with specific licensing requirements? That's unclear. It's not a question we address in the paper. But nevertheless, we feel that we do need some form of patent protection for AI. I made another assumption, like we have invention developers and invention developers and invention implementers. But what if we have integrated firms that just produce these inventions and also commercialize them? In that case, no issue, right? Because these firms can directly work and appropriate the inventions themselves. And in the case of universities and PRO, public research organizations, that is indeed the case. They are different. They cannot implement or commercialize invention, but in the case of AI-generated inventions, it's not clear. So clearly, if all developers, let's take the reasoning to the extreme, if all developers, invention developers, were also implementers, were also commercializing these inventions, indeed, that would weaken the case for patent protection. However, they will still need some form of patent protection, at least for easy to reverse engineer, for instance, inventions. How am I doing on time? 2 minutes? Very good. In addition to that, it's not the trend that we're seeing. So that's what we call in the economic literature the market for technology. And we have specialized actors who come in, invent, spin off, and then get bought by larger companies to transfer the technology. So we really have a specialization of the innovation ecosystem into invention producers and invention implementers. And we can expect that AI will reinforce this trend, because the skills you need to produce these invention machines, these AI tools, are actually not the skills you need to implement this invention in the markets. So we can expect the trend to reinforce with AI. So the case for patent protection is weaker if you consider integrated developers, but not null. And we cannot assume that secrecy alone will offer sufficient protection. And in addition, not all innovators are actually integrated, and we can expect less and less integration over time. So I think I'm right on time. Essentially, we are writing a paper we're still developing these thoughts. And in the paper, we discuss additional implications for the patent system. What happens to the state of the art? How does that raise should we revisit the notion of FOSITA or POSITA, the person skilled in the state of the art? Should that be an AI-enabled person, for instance? So there are lots of implications here that we discuss, but I'll stop here. Thank you.
Thank you very much for that contribution. We now move to online, to Professor Christopher Heath, who I saw was on the screen just a moment ago. Professor Christopher Heath is a member of the Boards of Appeal at the European Patent Office, and is also an extraordinary professor of intellectual property law at Maastricht University. Professor Heath, you have the floor.
Thank you very much, Anselm. I hope that my computer will not melt off as it has frequently done this afternoon in light of the rather elevated temperatures. But I hope that both my computer and myself certainly found Gaitan's talk extremely refreshing, also because too many lawyers in recent times have been hyperventilating about this issue of AI inventions and whether algorithms can be named as an inventor. And unfortunately, lawyers, different from economists, only have the answer yes or no. And most countries have said no, but for reasons that I personally do not find terribly convincing. For example, that some laws say that an inventor should be able to transfer the invention to an applicant, and how can a machine make a transfer and so on. Well, anyway, to me, this is a bit like, for example, in civil law, when you have small children doing something and then the parents have to act on their behalf. Now, I'm intrigued by the economic view because economists have sort of instruments that are much, or that can be calibrated much better to the actual situation in hand, and we don't. So for a patent system, it's rather give patent protection or not. And Gaitan, if you say, well, maybe we should, but we should give less protection, then I think this is great, but I don't know how we should do this. Patent protection is 20 years. And yes, it would be perfect if we had an instrument to say, well, but this is too much of an incentive, so let's make it 10 or 5. And we had the same discussion about different types of inventions, and we are still with 20 years and we don't know how to properly distinguish. So I very much look forward to your complete paper and how you intend to solve these issues. Lawyers, as I said, have not been too good at that. And if you, for example, make the proposal, well, then amend the European Patent Convention. Well, in 50 years, we made it to one amendment, which is not particularly good. So I think at the moment we are stuck with where we are, and this is with a decision that has said no patents on AI inventors. However, we may encounter, I would say, an avalanche of issues even with AI assisted inventions, such as recalibrating the person skilled in the art, putting more emphasis on the issue of plausibility, and perhaps doing away with the could-would approach, just to name some issues in a nutshell. Thank you very much.
Thank you very much for that contribution. Would you care to react?
Yeah, thank you very much, Christopher. The point about the EPC having had just one amendment in 50 years, I wasn't aware of, but it's a really good one. And indeed, that's what we call like the real politics of the patent system, right? And so that's why initially we thought, of some crazy idea. So maybe let's certify the invention machines. So we have examiners that look at the invention machine. Does it produce logic, logically consistent, novelty, blah, blah, blah. And then we would give automatically certificates to these, inventions arising from that certified machine. I think that's a nice idea in theory. In practice, it's unlikely to work and to take off. So maybe you could introduce another type of IP rights, like petty patents, which would be which applicants would be free to choose. And indeed, if you generate potentially 1,000 invention, maybe you don't want to pay the full fees to have like gold-plated patent protection as we have, but maybe some applicants will go naturally to petty patents, and other might also go to this softer form of patents. But indeed, at least the paper highlights the statu quo of, not the statu quo, but if we don't change the system, we should probably give traditional IP rights. If we're unable to change the system, we should probably give traditional IP rights on AI-generated inventions. Thank you for these comments.
Thank you very much. Also, a bit problematic because the move in Europe is away from non-examined patents. France has recently moved away from non-examined patents, whereas France was always the traditional country where that was sort of a standard for especially small and medium-sized enterprises to have access to the patent system. And what then remains is indeed a petty patent or a utility model system, but utility models have traditionally expressly excluded these types of subject matter from the scope of protection. Now, what is also interesting about the entire discussion is that Stephen Thaler, the gentleman that introduced DABUS, this device for the autonomous bootstrapping of unified sentience, that generated these test cases, and they are really test cases. It's a number of patent attorneys globally sort of filing on behalf of the machine itself, has made a big point that his machine is really sentient, and that therefore it should be treated as if it were a human. Whereas all AI academics state categorically that whatever Mr. Thaler states, the state of artificial intelligence is still not as advanced as Mr. Thaler makes out, and that DABUS, whatever the machine generates, can only generate this because of very strong human intervention. But I think Christopher has also pointed to some other aspects, and that is already difficult enough, where in the patent application, the bargain is always that there should be sufficiency of disclosure, plausibility. We move from man teaches man to man using an AI teaching a man using an AI to perhaps AI teaching an AI. And what does that imply for the person skilled in the art? And is that still justified in the context of the patent system that you're studying?
Indeed, so these are very profound questions. And that's what is nice about this paper and these questions. We can really think, deeply about what it means. I think about this AI expert commenting on the DABUS invention. That's kind of a fix. That's a patch. It's like, yeah, that invention, has required lots of human intervention. So still we have human input. Fair enough. Okay, so maybe that'll solve the DABUS cases. But we're getting there. It's clear we'll be getting to automated inventions. We see some popping up. And 5-10 years, we'll have more data, better computing power. We will get there. It's kind of sure. And so regardless of the DABUS case, we should question ourselves to this question. And then indeed, so we have machine-to-chip machines. At the limit, we also have machine examining examiners. So if you can produce inventions automatically, you can also examine them automatically. It sounds easier a priori than building a machine. So would we need a patent system 20 years from now for this, assuming everything? I mean, 50 years from now, who knows? No? But indeed, that also raises an important question, how patent office will deal with this.
By replacing Christopher with an artificial intelligence, no doubt, in judging these cases.
Go ahead, good luck.
Question okay, now we have questions, very good. I just want to say one thing. In 10 minutes, there will be taxis out in front taking us to the hotel. So they're already here. So questions, short, snappy, to the point, please.
Should I go? Okay, thank you. Yes, one short question. Do you see a difference in the concept of authorship or the relevance of the notion of authorship in terms of copyright versus patent, in the sense that in copyright, maybe creativity and the relation between the human and the work is more relevant than in patent, which is just a solution for a technical problem. So maybe in that case, we won't have a problem regarding the protection of the work made by a machine.
I thought I did. I thought indeed, the issue was settled for authorship and copyright, where shouldn't deserve AI-generated artwork, shouldn't deserve patent protection. But then some, copyrights-related material actually also require lots of investments in creativity. Substantial investment. So it's not about just painting. Could there are more substantial investment. So I have no opinion. I have no well-formed opinion on that.
This could also merit an economic study, because the argument in copyright is that it will be very difficult for human artists to compete with a vast AI-created public domain. So why would you create a literary and artistic work if that work, that musical composition generated by an AI, is as good as, I guess, most of the general pop music out there or something like that. And so this is the argument that is indeed used from an economics perspective. You can throw it.
That's the whole point.
All right, so I had a quick question. Incentive, I'm so glad you're an economist. Incentives. Why does it make a difference that you don't have the inventor of the invention machine as an inventor in the patent system instead of having the invention machine as an inventor in the patent system? So where does that change economic incentives? I don't get it.
No, it's just in the cost. That's the legal debate. Should we not? But the economic debate is. Yeah. So that's the legal question. But the economic debate, it's not about who is inventor, is the human on the machine, but it's about the cost of producing, essentially. If it's the machine, the assumption here it's very cheap to produce, and so you don't actually need to incentivize, because the machine just spits inventions for free, and so the whole. Of course, you need data and stuff, but whereas if you have human, presumably you assume old-style science, where human experiment, it's long, it's costly, they fail, blah blah blah. So that's where the distinction plays out. If that makes sense. If not, we can talk more.
Yes.
So possibly the question will really be: does the invention result to anything that is marketable? And that may require follow-on work, but that is not the question in relation to the patent system at all. It's simply whether you can bridge the valley of death going from the filing of the patent to an actual marketable product, which is an entirely different question. But also for that, you need, in economic literature, you need the patent in order to have the portfolio, in order to make that transition. Because patents in and by themselves do nothing in the market. You need a product to sell. Last question at the back.
Slightly outside your scope of research of IP and competition. Okay, is this clear? It's a legal theory question. If in your example, your inventor machine, would you consider that as a natural person or a legal person?
It's a legal theory question to
Yes.
which I have no opinion. I don't know. I confess my ignorance.
Okay.
I don't even know if it's matter, frankly,
It-
from an economic viewpoint.
It kind of matters.
Sorry, it's no person at all, because and this is, I think, one of the main issues when lawyers discuss this question, because the fundamental problem when we talk about persons is always attribution. In other words, somewhere the buck stops, be it with a legal person or be it with a natural person. And with an AI, we don't have that. And this is perhaps one of the issues why lawyers hesitate to allow naming an AI as an inventor.
Thank you very much. Thank you very much for that contribution, Christopher. You have had the last word.
Thank you.
That's very good. Last word of the day.
Thank you.
And I would now like to invite you, after your heartfelt applause, at least I hope it will be heartfelt, to immediately take your belongings and walk outside to the taxis. That would be much appreciated. Thank you very much. Tomorrow we will resume here at 9, and I think there will be some form of transportation provided for as well, from the hotel to here, 4 taxis tomorrow. But we will relay that information over dinner.
We'll return the nuclear football and be back.
Sorry.